puures pahtin anari. Lean suoma saametikki kulttuurchalli satjasas peräjuhana aslakuulla länsman ja toiman ne moderaattorin tan tilalla suodas. Fitnen tieto äskä ikte ähkädis ahteläh pläden muu laittestiätkin, kos on kiilei vuostatettiin plänejuvon lei pohtjan. Inläh kärkan valmastalla hietsan sähkävuoru änkalaskilli ja tanilla leän märjän saamasti. Toivumistuluhkon toima puures ja pohka pesse hipmirti maihleän muista lämmin. Otna konferenssa kielahalla taviriihkai alkoalamoki arpetiedu, tuoji ja immateriaala voikahvuodai. Konferenssa jotka saakastallama kolkkohmaanus koktetuha koktelois ortnejuvun assetouti seminaara vuodun. Konferenssa ortnei ahpahus- ja kulttuuriministeriä outtas suoma tahkivoikahvuodalla serviin ja saametikkiin ja vielä outtas immateriaala voikahvuodai ja alkoalamoki arpetiedui assetouti jouhkuin. Mieltelä mai ministeriä, museotoimaha ja patentta- ja rekisterhalttahusain. Tämän konferenssa ulumilillä ja puori taviriihkalla souttasparkku alkalmoki harpetiedu ja immateriaalilla vuodai ektui. Ja häälidihke erä tjelkkai puuri vuokatakai. Ulumilillä mai ahti erä vuokataa otso tiedu mi saami kulttuur ärpilie ja saami otso tiedu eskuudehke vuokatakai pirra. Tilalasvuohta ornejuvo webinaara häämis, taittakählä almuhan outal kiihti. Tän tilalasvuotas pahtamai pätten, man sahta kähtsä tän fitnu siittus ahpaus- ja kulttuuriministeriä siittuin. Tilalasvuotas lää tulhkon ja tulhkon rusteka. Tulhkon toimat tain kanalain. Okta englantta. Kokte tavisamekielä, kolma suomakielä ja neljä skantikielä. Talpiuttan suomasaametikki saakatoalli rahpahtan konferenssa. Läke poritumisessa.
Puorit konferenssa kuossit porre idi mukepelis puhkaitte. Samtikki saakajohtahetsin saavan tin puorispuhtintaan konferenssiin. Tavriikkai hemi almuki harpevirulas tietuu, suojis ja aunahis homotakas. Konferenssilla valmastalla juvun kuhkaa ja fuolalatsa ja hallitankin kiihtii herran omatsi Suomen ahpahus- ja kulttuuriministeriä. Valmastellaan parkku koordineeramis, tässä lassi hallitaan vaimalatsa kiihtii maittai puohkait, ääräihkielä leamassa mieltä laakileemen konferenssi. Puolan sähkövuorustin sammustahti kolma tehällä saassi opnaa saakastalla miit vuoduun. Vuostamutsan hallitaan pukti saakastalla miit ja konkreettilla suola. Konferenssain mitä aujaa, huumat tai haassi pirraa, almolas tohpaki pokte, teko arpevirulas tiehtuu, tai aunaa hisomulat. Hallitaan taal, tjatnataan viso, oassin saapmelas päivällä sellima ja ellin kulttuuran. Kun mi haalla saapmelat se arpevirulas tieduus, mi huuma polvaspulvii sirtsuun arkapäiviä tieduus. Mi ain taalke toimaa outomerkka tihti arpevirulas elahusaimme huoduun. Tälle tiehtuu herää taas, moh johti luontuus ja moh haafkastalla heskulle laakan sattuit. Arpevirulas tiehtuulle saammelat sai haunahi soomota, saamme lahkaa koutomerkka tihtii lohtii, löytte ja löydy. Nuppiaasi, manne tähäläs muihtii, le lahahte saammelat sal hokta alamot. Kuhte allalta naikki neljiriikka kuupluin. Tän tihtii katsaltakaan, että mä kuskemin arpevirulas tiihtui ja aunahi soomotahkii taujaa, koska he saamelaiset rastaa raajait. Takkar katsaltakat kieltähallojuvi Sámi parlamentaarilas raadis, mille saamitikki kaskaasas parlamentaarilas ohtsparku orgaana. Raadi toimaplaani le kirjajuvon Sámi hoktasas tavirihkalas linjemit haamen. Mi koskaa saamelaiset kulttuurarppi ja arpivirollas tieduu haltsäämi, suotsaleemi ja aukastallami, sihke suotsalan tarpui ja taapiitte. Ta parkuu le ainkaskan saamiservosis, mutta saavan ahtemi päässä farkkaa outaani tai linjemit haamemis. Kolmaadin haalitan teettuhi ahte pohsaakastallamit ja suokkartallami haktavuodas, ma laktasi tai faattaitte. Kalkaa vuhtiin vaaltii saamelatsa hiesmerretan voikavuoda. Iätsä harpivirollis tiihtuu ja erää kulttuuraarpai. Le tehällä sahte mii saakastalla tai tohpaki pirraa almolas ja tavirihkalas taasis, mutta seammas kalkaa sihkaarasta juua, ahte maitpäin saamme servosus le veolosvuotta vuos siskaltasat merriti linjemi pirraa, ma kuskemmin iätsämme kulttuuraarpai ja harpivirollis tiihtui. Saavanahtesta ahtasahti toarjuu hietsäsehuasil saamiservosa parkkuu arpivirollis tieduu suojii ja aunahisomulaka riuftii houtii maittai pohtivuodas. Ta tahpahuvaa outomerkka tihtii saamitikki toima resursseisihkarastima pokte ja takkar sakastallan foorumit laakidemi pokte ma falle oas salastin veolosvuoda jeskude toima peiliitte. Tässä lassin lyhtsy tehällä sahti servosalas atmosfäära almollas taasiin outaan ahto takkarin. Ahtata faallaa veolosvuoda takkar saakastallamit outaan ahtiimii saamelas servolakas. Taloudamerkka tihti suomakonteustas storimo suossi saamitikki resurssain, vaan nasaamelaiset voikavuolai houttiile mai almollas lahka-asahusa ja valtoservolaka rahkalusain. Tämä lunttolat tolvuu resursseja saamelas servolaka siskaltas outaaneemis, masa miis teko pois servolakain leamai tarpu. Le vuorrähte Suoma outtila ta virikka ministerraadi saaka jodihetsi programmastis ta virikkaat kaskasas outsparkkuu. Man ulmillinen emialmoki harpivirolais tieduu ja harpivirolais kulttuur almaneemit suotsalemi aunahes riuftiikkuin. Saavanahte opne, mi juotki ja outtiili jo mannaan sautsa virtuaalilas asetoutii seminaaras alkahuvon puorii saakastallama, immateriaaliriuftit ja saamelas arpivirolais tieduu suojii pirraa. Saavan pohkaitte erinomas puorii ja maussulas konferenssa. Huilu kiihtuu muu pelis.
Ja tällä maittain Eera saametikki saakatolli sahkavuoro. Vuostasin Håkan Jonsson kaittusin.
Kiitos. Syns jag? Är jag med på bild? Och hörs jag? Först så vill jag ju tacka för inbjudan och även tacka för att det här seminariet med traditionell kunskap och immateriella kulturarvet också, att ni har arrangerat det här. Det är otroligt viktiga frågor. Den samiska traditionella kunskapen är ju inte nedskriven, men handlar ju om praktisk kunskap och beroende och samspelet mellan natur, djur och människa. Den traditionella kunskapen, den har gått mellan generationer i tusentals år och format den samekultur vi har idag. Den traditionella kunskapen, den har hos tidigare generationer av samer varit självklar, men är tyvärr idag på väg att falla i glömska. En av orsakerna är den kolonisering och assimilering som pågått. Och därför är det viktigt att Sametinget, men även det övriga samhället, respekterar och ger resurser för arbetet med att vidmakthålla den traditionella kunskapen och det immateriella kulturarvet. Den traditionella kunskapen är grunden för det samiska folkets existens. Den traditionella kunskapen och immateriella kulturarvet är också nyckeln för vår framtid och till hur vi ska skydda och värna om vår natur. Vi ser att utövandet av den traditionella kunskapen försvåras av bland annat bristen på information och dokumentation om den samiska befolkningen och deras situation, samt av den utbredda okunskapen hos beslutsfattare och allmänheten om det samiska folkets kultur, näring, kunskaper och rättigheter och möjligheten att föra vidare den traditionella kunskapen och det immateriella kulturarvet mellan generationerna. Därför är det viktigt att det blir ökad respekt och tillämpning av traditionell kunskap inom förvaltning och beslutsfattande, inom samhällsplanering samt möjlighet till ökat deltagande för samiska kunskapsbärare i beslutsprocesser som berör dem. Den traditionella kunskapen passerar alla gränser och förenar det samiska folket. Därför är det en angelägenhet för alla samer i de 4 länderna Sverige, Norge, Finland och Ryssland. Gito.
Ja te Norkka saametikki saat ne jo lihat siljemutka. Läke porre.
Saametikki presidenta Puerihalla arvosas quessit ja konferensa vassavaldit. Meistä neljä jaajille Gollandan rajes, kun mangimus tjakkaneimet teike aanari digastallat tai köytäsi äiki köytelis assit, namallasti min kulttuur, arbi ja min arbevierut. Arbevierut tai maidai immateriaala kulttuurarbi, man satsi mai kohtsadit njalmalas polvai mel uahpahuvun arbevierut. Nu muu politiikalas kollega Aileniika Mahte okti taajai. Le dehalas vähäs suoskadit ja suokkardallat tai tuohpagi, kun sahte muhtimin lähvahtis fahtetan tuottaa siistuallu ja revts lahkai adde mastasle saakka. Jos kalka fitne pueri kuulahallama fadda birra, teille tehalasta puokka addiit ja ohtavaivilismi tuohpaga siistuallulle. Ja taas sahta kaskuhaille hastelusan täkkeräs oktavuodain. Nu modal kogalke laukki tantehallas fadda ja gärtsadi muu sahtasi suoji laagidi min teures arbeveruide. Ile makkagi tjegusassi, että saami kulttuuri ja arbemahtu ja diettu, le äänet pinnuhakku kuessengia outal. Ja tahillu tahtamu. Tammi vuotti päivällätsä puht tai puhtakin mahilmet. Pohjärjeldagan ja tankarra perustumis mai muana saami outastegi vasihit tai äikit. Erinomaisesti manga Disney-prosessa, mas maitei saami servuda vasihi tehallas olahusta, kun siehtadallamme hofta maailmis työrimus fitnudain, ja odjumme satsai historiallas suohpamussa, man vollaitsalle 3 saametikki ja väl saameraade, kos tjegasi tatsua, että saami kulttuurarbi lä saami opmudat. Tällä tehallas prinsiippat selkämus mai kalkaseimme tuhtandahkat nu johtili koveilas, tuhtandahkat erjamat sotjalan visiona ja nu tahka veiladjan tuste puhtaan perustumi min kulttuuri pueri vaikkai. Taat tuhtandahkan saht simai puhtahi harvo rahkadämme ja nu saattaa tehallas oessin saami servudat huksemis. Saametiki pielesle moi tjaadan kuekte tievastjakin assi. Ja level alkahan projekta, namalasi imkas projekta, ouda projekta, mille tjövullämi saami parlamentallas toimaplana aikumusas. Maidamin odda samos politiikkalas dokumentas, mille da politiikkalas voddu tjövuvas njäli jahkai, päivi alku julkaistus, tallemi doppemi lohtemi arbetehtu ja maidai immateriaala kulttuurarbi politiikkalas agendai. Samedigi läge angerit tjövun ollestan konferenssaprosessa, jolle tjelkasatte misle ain olu tehallas parku patsan, olhan diite tuota iesmeridämi tai kajaldaida. Ja dan olis hallidan tehty hit, että lää tehallas, että Sámi servodat iespjässä raafis ja edjas evtui melte tiigastallat, mo sötjali min edjamet kulttuurarbi. Tämä lämmas min läitestegi tuollaja räjes, ja kalke fast min polvai läitestit outskoului. Sui itsekin resursseja käipidäji. Tannelle mai pueri ja tehallas, että fadda lohtjuvuut aviriikkalastasis, ja mille hui kiihtävät, kun maita ei eisevälti chaihi tuorjun, tahtuu ja perustuumi Sámi kulttuurmahtuu harrai. Mi tarpasaa tuoriaga tuohtandakkat iedjamet iesmeridämi. Ja lohpas hallidan kiitti Suomaa ohpaus- ja kulttuuriministeriä ja puht oftas parku kuimit, kolle nu ankeri ja arjalautsa toimahan tämän konferenssa. Mun saavan liikkuu konferenssa tjadahämen ja kiittää muu oasis.
Vuorusle Suoma staahta tervoilla. Suoma ahpus- ja kulttuuriminister Antti Kurvinen sattan mitjie filmatervoa. Tällä vuorus täällä.
Good morning, everyone. Nordic and Indigenous experts in traditional knowledge and intellectual property. I am very pleased bringing my greeting into this conference. This presidency conference today is a unique one. It offers space for the indigenous Sámi people's perspective in issues related to protection of Nordic indigenous traditional knowledge. This includes, as many of you know, for instance, the traditional Sámi dresses, so-called kakti, hard and soft handicrafts, I tried to pronounce Sámi duochi, and many forms of joiku. As we all know, these are cross-border issues and therefore cannot be dealt with only national level. Dear audience, the Finnish initiative for increased Nordic cooperation contains measures on 3 levels: a political, a practical, and a substantive level. But I think we can reflect on them also from our roles as individuals, professionals, and policy developers. The awareness on the sensitivity of indigenous cultures has increased a lot from my youth. However, the amount of education and awareness available on the Sámi culture in Finland and the other Nordics is limited. Therefore, it is important that there is enough information available of Nordic indigenous peoples. Also, we need to start providing more opportunities for open exchange to have an inclusive way of addressing indigenous issues. I'm very glad to say that there will be a forum organized under the Finnish Presidency of the Nordic Council of Ministers in the same building you are in, the Cultural Center Sajos, on the topics of Sámi education in December. Dear conference audience, apart from general awareness, it is important that young indigenous professionals receive education in intellectual property specifically tailored for their needs. This is substantive level work among experts specialized in indigenous law and practices. For example, the use of elements of the Sámi culture by third parties for commercial gain continue to be a considerable challenge. The demand for right information is important also because, as we have seen, in some cases, the fear of cultural appropriation can have a worsening impact to indigenous-led businesses, for example, the traders of Sámi duochi, Sámi handicrafts. The buyers, mainly tourists, do not know what elements are appropriate to use as members of another culture. I'm glad to hear about the initiatives of IP offices in Sweden and Norway to address the needs for IP awareness and education of the Sámi entrepreneurs. This is important as often small and medium-sized companies in every culture know little of how to make the best of IP rights. Dear audience, we Finns are taking this issue up as part of our Finnish Presidency of the Nordic Council of Ministers. Why we are doing this? Because we believe it is in our common Nordic interest to learn more and understand better these complex problems. Naturally, I'm hoping that this initiative will be carried over to the Norwegian Presidency of the Nordic Council of Ministers. Congratulations to my new colleague, Anette, who will be continuing this important work. We can learn to address these questions step by step and find solutions for at least the future generations of indigenous people in the Nordic countries. We have seen a trend towards a more sustainable IP systems also in Australia, New Zealand and Canada, where these issues have been on the table for some time now. The Finnish initiative does not contain formal negotiations. Our initiative is an invitation to listen and assess the indigenous view to the protection. Nordic solutions may eventually emerge, for example, within the framework of the Nordic Sami Convention. Intellectual property is a very good tool and source of empowerment in today's increasingly digitalized world. Intellectual property could provide for a significant tool for new indigenous businesses to grow over the coming decades and provide income to the most remote communities in our countries. The objective of the Finnish initiative for increasing Nordic cooperation is to set the scene for future dialogues to take place together with indigenous peoples and among all the Nordic countries, including Iceland, Denmark and Faroe Islands. We would welcome views from Greenland, Inuits too, as input also from other indigenous groups has the potential to deepen our growing understanding. Via this speech, I wish you all an inspiring conversation and a great conference day. Thank you.
Täällä alkahi päivi fatta kuhtiin saametaittarin ja sutno ainuun päivi fattain. Jouvatsa kulla tuojar Petra Piire Makka Vars ja musiikkar Anna Näkkäläjärvi Länsman Outapuktimi ja Tanmanjel Aini Anhis Film. Näke puore Petra Piire.
Puore päivi puhkaite ja puures puhtin anari. Kihtan poutujumis ja jambelis. Rapan otna päivä fatta anhis sahkavuoruin tuojitilis ja jam vaasahusai vuotul. Haljankal vähän jalmustahti ahte lähtee paida muu tuojarin. Saapmelatjalla hoi nöijä, hoi tehalatja tiesahte ki ansha saatan tuojara namaa. Ietsän päällis munin anshastan. Mulla on hui ollut vähän aikki tjohkin saaliin, taapalas parkkuin ja teihtelen vähän kaitan eerehtan tuutjomis. Ja mun jahkan nie tahpahuva johke okti ki ferte parakat alap muka outi. Tahe ferte rahtsat peärasa tuotsetarpuje. Teuske lään pajashattan takkar peärasis kos tuutsionle arkapäivi. Lään hui ollu ankirussan teinä ahte mun ootson tämän arbetiedu haltui, sihketal raavesolmotsin, mutta maittai lunttolatsan talle, kun lekken maanna, lekken hui takkar teko ootsolohka sahki, juovu, mi pirrasis tahpahuva. Ja tämän pokte maittai pessen oahpahjoita, toutat, haajai, päässä kuoska, tihto, autnasi ja maittai ies kähtsali muhtumin, että nahkuin, tihto, vuuki, tahka, joita, kielaikuin. Tästä kun mun sitten nuora mun harjahallen tuutsoma ies, jaska, mutta jären alo vähki, kun mun mielestä tuutsomi tehalas läätä kaskusteäpmi, oahpahäpmi, saakastallan. Ja maittai tahkulla hallan juur tuodas ahte moossahtaa tahka ääralahkai, tahe moo muhtuun äärä olmusla oahpan. Tuotsi, tuutsoju voi outal aalo atnui. Tarpuja käävähäpmi, nukohtsutuvun käävähän funksuuna märidi tuoji aunasväljämä ja haami. Tän mai tarppasit, tän ton paraget. Ja tän ton tahke tuohtan, vaihkotus liuhtsi tsiejamaana. Tiksuma raajes kittatan karvestuotsai ja tahla prosessa. Outalko ton aina vaihko nuuftohit, tonni jopa tiedäke man kuhkes matki leätan karvis nuuftoha radsai. Ton kalkkaht nuova pohtso, ton kalkkaht juohpaht julki herehte tuoljus, ton kalkkaht juohpaht jallihtan nahki ereht pohtso joleke tauhtin. Te tammanjel alkaa äskatan autnasa tiksun. Tiksumi tuskalakalle karvisin, vidjon ostuht, parhkuht, tuskalakalle tihtolakan autnasa, jiehku. Ton verte tiehtiht mohton vurohkotahtait. Ja te ton verte vel juovuhta naikki. Koastu kaapmakahkalke tuotaille karvisin. Koasaleke puollasat ja tusverte läht kaapmakaht karvisin teutojuvon. Outalkoton valta atnu ja haalidit ahteta toimme nupuures, ko min arpe tiehtu lää muistalan ja arpe virule ja juuvontan päivai tusverteille kaama suinnit. Maikkuin ton teuttahtait ja käävähtain julkit liekkasin, mutta kaama suinnit ton vertet jo outalkihtii tälle käsiaikke lohpakässe paraga ja juohpat. Tsähpes tuojar lää maittai taht, käslei ipmartustan tuoji tiksumis. Jos juoka pillahuvo, tetan niin tarppasan palehkesti, kun puures rahkat von tinkkali vejolas tuoknjat, unnidit, stuoridit, voitaht, odasmahtit ja niin ain. Sámi piktasah 5 vuotain haapmejuvoin, kalkkaille liekkas ja vuoka salte, ta heilän tuuse tsytnjan tahkon, tahleke parako piktasah ja ta verehtii kerrata mai lihkastakai. Hervahmin arkapäivis muistali tan, ahte mis lää tarapu tsytnjadihtan maailmis. Kanske ta lää juste taht estetiikka, man mille haalidan tuolahit maittai. Kauhti malli lää seilontan otnatsi, mutta tah kuoskaa tal otnapäivän enemusta avudeap mai kuoski arvu sohki kullevas vuoda perässä tuutsomalli houtan pukti ja saanehis saakastallama servosin karvodäämme pukte. Ja mulle onkin lohkanahte kaktilateko persona luohti raahkaduvon tihto-olop mui personalatsat ja tan ihsahte paljon luohkahi ära-olop mui. Ja taadi paha puhtaa tuotsi kakti, millä min piuhtas. Tälle puohäänemus suolaaduvon ja luohkahuvon iskude variasuunnaje. Tälle kun mun sokkan kauhti, mun haalia muisteli kiimun lään, kos mun poadan, jäinä mulla naihtalan ja kään mun kutnejahtan, tahe man mun kutnejahtan. Lään formasan tämän ahteko misläh älillan olopmohtai arbetiedui kuddit, nissonat oudamerkatihte. Si puhka läh ällan tekardilis, ahte pensiona ruhta ilä tsokkon. Mulla unohastan kulla hotna päivä, ahte muhtun älillan olopmoh ahkuhle tadjan, ahte ooga mun sähtäsin vielä tsokka kauhti, muhtako ei paljon paatse elhusruudas osti vaikka laadi. Taht globaala maailmi lää tahkan mittiötä tihtolakan hastalusait, ahte mii seutsit tuutsomiin ja taina tuuji äläskahtimin. Saamekellä rikkoda sististolla mai ollu tuutsomi kullevas saani. Tuutsoma oktavuodas lää shotta mankka luodit, mahla sististollan tehalas tiedu, arbetiedu. Tuutson lei servostallan ja maittai oahpan ja tahleita alapma kulttuura siritin areena. Kittat ja naunastemi raajas. Tehtolahkai ton färte tiehtit. Ies läht tahkan joita arbevirolas parkku, vaiton sahtaht huppmahtan päälis ja outtedihtan. Jos tus iilähtah tiehtu, ihke alketan haahkat, tus lää vattis teko outtedihtan tiesa ja tien pohtosi manton haaliidat. Alako alapmoki iätsase sutsemekanismi kullaa muun mielestä tahte mi haaliidih tuodai säiluhit. Mi haaliidih tuodai siritit. Mi jahtoala tihto lihtisistä ja lohkikittata nashi. Tah lämmin varas, ahte maana päässä aihtsat, maana päässä lähmelte, arpevirulas parkkuin, maana päässä kulla luodi ja tiena laakin tahteko vahakis puhtaa jotain kulttuuripiiri ja edes arpeviru ohpat. Mun illuan tal ahte Suoma ministeriä lähteko chatnan edsase ja rativiseeren tämän maana strategia tal 2004 loki. Tahan kal torjuutan ahte min maanain kalkkasi läht empo veolasvuoda kalkkasikke tohko skuuli Aasahi Sámi tuodje materiaalai ja valti ohpahus siitai. Mutta tadi pahapui min maanain ille veolasvuotataan oadjut. Tjovas haave ko alkaa vas vuodo-ohpahusa ohpaplana odasmahtin mun haalirivtsin oitnihahte toppe kietne kahtojuvu maittai ohpaplana Sámi ohpahussi tuoji ja luodi juikama ektui. Min tuoji läh matkosta maailmai tolosaikke tal ollu arkivan ja tahla mahtsahuvon sääpmai ruoktomuseaie. Ja taitte tolos taveritta ja tuujitte kalkkasilla hui alehkes vuohki sääpmälätsä ja ohpasnuuva ja vaasihit. Ja fastouta kullevas vuoda ja kanske valti atnoi tiihto tuuji ja hervenmalli teko ruoftolotta. Takkar vuortamusa lähti sihkari Sámi tuojariin ja taapala sääpmälätsäin musea tappe tavin ja tah kulttuurilaakausa sahtit. Hutka mittiä takkar vuokadaka mohmi pohte lakapuihtan mahtsahuvon arbetiedu. Sámi tuojara hei kaudno, tahla mai fakta. Mie juurtilih kallahte tahla ollu, jos Sámi tuotsi servisle ollu lahtut. Ei puhkat, ta hei tuutso päiväladjat, niahte tahlivtsiita valto tienastan tuutsomispuhtan päutai. Tah tarkkuha tanahte, tahläht muihtu meltetään tihto laakan takkar kärhtema tutkamusa vuodulahte kuhta Suomas. Sulli kuhtalo jähkäsadja läht aipas tiineihtan tuutsoma bokte. Tällä olle unnan. Mantihte min nuorat ei läht nupeirostuvan. Joo, si läht, mutta si tarppasi maittai toarjakit. Tällä ealahusto arjakat. Tuotsi tarppasa maihtiihtolaakan vuokadaka. Ahtelivsi alehki alekit tuutso päiväladjan. Outtidihtan Sámi tuoji ja edes tsehpodaka. Ja teinalaakin maittaa jo atso ealahusa. Ja mun mielestä tällä oktaman kalkkasivalta vuhti. Ohpahus ei läht ordnejuvon Sámi kaipalusa mieltä. arbetelu hältäsetsi roolalle aina maustolastan tuoji ohpahämis ja tämän kalkkasi loktet teko tan taas sai. Nuko kalakaa. Mi aitni hahte tuojar. Tahlää min arbetelu professorat. Sishän lää aitni tan moh kaktikalaga läht. Mohta lää ko olmos lää chaappat. Lääko kaapmaka nonni tiihtokoului noloka vai potnjut. Tuoji hehtehussan lähmäi kilivälle jedinkka ja tähän lähjustetat massa puhtadeemi. Tähän nuulassanan. Teuske lävalle tiurasastit alapma tuoji, koton vertitahtan halpes tinkkaje, mutta man kuhkaata pistaa ja miilätään arvu ja maihtahattaa tuu ejät kulttuuridentiteetti. Lää tjelkäsi mai tiihto tuoji mahla kauppetinkkat ja maitte äilä chatnon chauka norpmat. Lään kullan takkar saakastallami ja olopmohla valtan oktavuoda. Ootjonko mun asti kaapmaki nuhtohi vai vahakahtaako taht sääpmelatsai? Tän munin haaliryhtsi ahte tuojariht ällinkäit nu nohkaa. Ilä oktake olmos ki sahta ies oktomääridi kollektiivalas opmodaka perra. Millä halle saami alapmot ja miskalakalla oktasa saitnu. Ja millään saami tuojari haitnu. Saami tuotsi serviroolalle ja tehalas saami kaskas. Vaikko ta parku i aalo hoidnonu aktiivalatsat, koihtokke tahla oktake äitnu, ukti edes tuuji holkkos oidnosi. Tadi pahapui. Saami tuojarat kärhte kelivalihtain ruudain, koka lakaa ohtsa projekta ruudai. Ota märkä tihte. Toppeläht aamma taittara. Semma raittus tjuoltsume ja ohtsamme ruudai. Ja saami tuojar, se on lää ies ohpan. Se on lää arpetiedui pokte ohpan. Sus lää ihan ääralaakan tuokas. Mutta alohtahi, tämän ei olkkopel olmas sähte aitni. Semma tilisteko tai alapma taittarat. No, tuossa tuutsa, minkä ei pirike tantihteko äällillään olu tiuron. Luontu äällä eäs ritma ja tuojarkalaka aitsa luontu aunastamme tihte. Oktala talahkala riutan millä maittai tahkan hehtehusait tuutsomi. Nuuko outa märkä tihte tan tjaktjat äilän kuopparat ta tarkkuhi ahtamin sarvat ta hei nakolan shottadiht alapma nanu chorvi main liuhtse puures otsun tuotjaunasi. Sihke tahvai kuhan jolka pohto kuolkka shatta läpmai. Sihke tihto shattuje, ahte mohlea lähko käsit tiekkarahahtele arvit vai lähko käsi pääre pahka tai koihkosat. Ja nie ain. Tietuske talahka reutan tahkaa tienke ahte miitappe taavin läht vuostamutjan rahtsametaina. Mi sahti vahkestaka kaita heerehmai tihtolaakan pivui käävähämis. Pääskai ja kalsohi, nuhtohi, talavilla otnon ja kummesteevalla soihte mannavel nuhtohi outtabellaina muhtumin. Mun illutan koihahte saami pääräsin atnutuotsi oitno, vaikko viso hei kärkka tan vuotin päutai. Tän sahtaa vielä laitnihahte pääräsin lää toiva ja maanain läh kauhtit. Ja etän parkku päälis, kolan parkan saami maanaihkulttuurikuotatsis farkka kuoktelogiaki, ainan tänahte maan ollu millä massan ja tai jake haikke, kotah min äälillan olopmo hahku ja adjat läh sirtasan tohko ääräpellai. Takkar parkku mai tiilähte paragame ja mai millä jurtilääme ja haali houttiidit saami puorin. Taina ei kalkka aajahallat. Okta jahkike, lää kuhkes jahki. Alako alap muka perspektiivas. Mun sahtan lohkahti kuoktelogi jakis jo, missä hirpmah ollu tai arbetiedu hältäseitsit. Mannan äärä maailmai jaapman kuodammin ja talle lää nuoraipuolova vuorru valti houttas vastausa. Rähkaako tahtasto, lääkö tahto arvai, ahte ei mahteke ollislatja tuudjot, mahtautu se muhtun oosiit. Hui taapalas lää, ahte juohke nisu ja neitä mahtaako selihkirjassut. Mutta Sámi pohtiaikke ektui, lääkö tahto arvai. Lään iätsän parkkus haalidan nannet ja muistuit alohtan ahte lää tehalas oahpahtan mai ahku ja eetti ja adja ja ahtjilla mahtan. Ja teinä laakin kalkaa mauhtitahti mai maanai. Teuskeko rudaa hei kaudno, tadi pahapui rudapirrakellä saahka, jos aikoo palahkahi olomui. Tällä hui vattis nuko ordne tiekkar toimai. Mahlähteko kuhkihaikki prosessat. Tässä lähtusse joka parkovuokki, maihmi sahti kähtsälit, ouhta unna parkku pokte maanaikuin ja teinälaakin oahpat. Mun kiihtan jätsän päällis ja saavan titjude hui maustelaskonferenssa ja mun haalidan ahte juohke oktaa tämän konferenssan manjel. Tutkaataan öjäs vaimustis. Millä alakoalat muka roolla otnapäivä globaalla maailmissa? Lähkomi kärkosat säilyhit, saami kulttuura ja toarjuhtan. Kiitos.
Kiitos Petra ja Anna. Laudi lätu.
Good morning. Thank you for the invitation as a keynote speaker and giving me an opportunity to talk about the Sámi vocal music traditions and the need of protect the traditional knowledge that they contain. There are many different vocal music styles in Sámi. I speak about joik, called also luhti, which is the tradition of my people, the Northern Samis. I'm sure that the same principles can be found in other Sámi vocal music styles as well, such as, for example, leut, luut, liude, vuolie, volle, and arme. I have been growing up with joik, though we didn't have anyone in my nearest family who would have joiked in my childhood home. Luckily, I learned some from the Sámi school and from the Sámi popular music and Sámi society, and I got to immerse myself to joik with some archive recordings I found. Now I am doing artistic doctoral research to Sibelius Academy about taking back the joik. Joik is much more than music. Joik is the memory of the Sámi people. Joik is the philosophy of life of the Sámi people. It contains our worldview with ancient beliefs, gods and gestures and way of living. It can be performed or it can be a practical expression during the ordinary working day that connects us to the chain of the Sámi generations. Joik is told to be the oldest still living vocal music tradition in Europe. It has a lot of hidden meanings and functions that only the people living inside the Sámi culture and certain communities can understand. Joiks are dedicated songs, which means that a joik refers to each object and to everything related to the object. The joiker describes the objective of the joik with the joik performance and with the chosen interpretation. The joik can be joiked in many ways. Nowadays, when joik has partly moved from private environments to public stages, the former functions have partly disappeared from the joik culture. Based on Sámi common law, we still think that the persons that are joik owns the rights to the joik. The rights of the old joiks are owned collectively, meaning that the community governs the joiks. There, where joik is still a living cultural form, it's crucial to ensure that the chain of the joiking generations will not be broken. The living joik environment needs protection to keep the vocal tradition still the oldest living vocal music tradition in Europe. In case you want to protect the joik culture, you must protect the whole Sámi way of living. It means that it must be possible to live in Sámi way in this time and in the future as well. It must be possible to make a living from the traditional livelihoods in this time, meaning that the primary production needs are considered in the priority. Then we are helping the people that are living in symbiosis with the nature and at the same time ensuring that the Sami way of living and culture are abiding. The main reason that is making yoik disappear from our everyday life is that the modern way of life is taking more and more space inside the Sami way of living. This tears the communities apart and weakens the cultural interaction in the communities and between the communities. These days, Samis live around the global world, and yoik is not necessarily needed as a communication form inside the community anymore. In this situation, it might not be important for every Sami person to keep on yoiking, and the yoik disappears from the Sami society. Also, the old burden from the Christian revivalist movement that said that yoiking is a sin still affects in Sami community. One could say that at the same time, yoik is really valued cultural artifact amongst the Sami people and among the people outside as well. But perhaps at the same time, yoik is the most confusing artifact as well inside the Sami communities. In many families, the chain of the yoiking generation has broken down, and the new generations don't know how to yoik, not socially or musically. I think that the yoik needs to be protected inside our minds. It needs protection that makes the whole Sami people value yoik as precious as it is. Our spiritual heritage and our history told from our point of view. The colonizing process to take back the yoik where it is lost needs to be protected. We need to protect the living chain of yoiking generations. We need to protect the old yoiks for losing their original meaning and becoming only music. We also need to protect the old yoiks for outside use. We need to protect the archives, including Sami vocal music recordings, to be used in culturally sustainable way, also inside Sami communities. We need to protect the traditional knowledge and functions that yoik has. I hope that in the future we have a living yoik culture at homes and inside Sami communities, as well as in the public arenas like schools and concert stages. We need support to achieve this. Thank you. Kiitos.
Kiitos Anna. Filma mantal aini lää tahkon aida proseutta oktavuodas. The Arctic Indigenous Design Archives lää taviriihkalas outtasparko projekta. Filmas tuoji professor Sami Allaskoulas Kunvor Kuttorm, Senior Research Officer Sami Arkivas Inkeranni Linkola Aikio ja Aihte-museuma kurahtor Anna Westman Kuhmunen saakastalle tuotja-arkivai mankkapäällä rollas. Filmas maihkulla tuojari ainnui. Täällä aini Aasassa tämän filmas.
Ahte muhtima hälidippit ja sierra ävtuit. Vaikko ahte digitaalallatsat IPAsa tämän ainit tämän materiaala digitaala häämis outalkolle komannan vaikko kekteloi vihtajaa jevi neljäloja ja maite vitjeke määrin. Mutta seammasti jos mi ferte maita juurta sitaan ahteta materiaala lät tahita arkiva lät aiviltuvon kevähussi ahte miessähte tusse säiluhi tai ike oktakepeässä tai oili.
Takkarko hukse takkar digitaalalas arkiva. Tälle fertelle tärki lähtee, kun sääpelatsaa lää vähän takkar eksoottihkalas stämpel. Ja täällä äikkis lää hirma häälehki hutkaht puktaki. Ja nuo rahkahti tai mättimäilmees tuoda fabriikkain. Mun vähän palanahte muhtun lähetteläs ohtsaa inspirasuuna tämän arkiivas ja tästä tinko Kiinas puktaki. Mä lähdin mahkaa säme puktaki ja puuta tai. Ja tästä säme tuot servota hii. Tää silleen säme servotahki äykki. Tammu vähän palana. Tätä on Ferttesi Mannulahkai Sutjekalla. Tämä on arkiva kieva hiemi. Ja mulle näette nähdä nuohan tähän lääkin.
Jag vill inte att mitt arkiv ska publiceras på nätet, att mina bilder inte ska läggas ut på nätet främst. Främst är det ju det att jag vill att när man ska ta del av mitt arkiv så ska man göra det på plats där arkivet finns. Och det är för att idag med all den möjlighet att sprida bilder och information så blir det lätt att någon ser en fin bild, ett fint band, ett mönster och tänker ja men det här var fint, det väver jag utan att veta bakgrundsinformationen om bandet, vars det hör till och vem det hör till utan att kunna läsa bandet.
Takal pietellä vahpia tätä. Oletko tatsa piedä saamlats nuora? Oletko nuutat? Voitko Uolakaka huaivia. Tahoitukia. Tällä saamia tuojia. Teikee vaihnu tällä muhti niitä holomma. Tällä plagierai nulluis nylakatatsa. Takainen nullo plagiaatteja. Tein kun tämä villuvo muhtima. Ja ketällä saamia tuojia. Tionka leija harpu virrakal tuvu miltä vihko kohria uuta ja parkkui. Takal tuvu miltä voita huinaa nuo lehke tiepieltä. Te jos saattaa valta te harpu virran jurotoke ja pizzatilia just kalakatatsa hurraikas. Mua ei ole hurraika Kiinalatsalla tahkan tuavitsa.
Jouvatsan lää sahkavuoro olmosis kiilää parkan issora hänkiri tan konferenssa outii. Lääkepuore Anna Vuopola, Suoma, ahpahus- ja kulttuuriministeriös erinomas rätteätti. Lääkepuore.
So, good morning, huomenta, good morgon, vuode itchit. Welcome to Sajos, welcome to Sámi. At the Ministry of Education and Culture, we are honored to have you all here. But half of you are here. You are physically here and the rest is online. And they are not able to hear me right now, but I can still speak a little bit, I think. To talk about this year, we have had a wonderful opportunity to work together among the Nordic countries to prepare for this conference. We've had over 10 meetings with experts in the Nordic countries. And thanks to the COVID-19 pandemic, we would not maybe say that generally, but because of we've had more time than before, let's say. We've had time to meet online. The Nordic team is composed of 50 experts from all over Sápmi and Nordic countries. We've worked to drive the topic of increased Nordic cooperation in the protection of Nordic Indigenous traditional knowledge and intellectual property. As you know, about these topics, we've used the abbreviations TK and IP. TK includes also TCEs, traditional cultural expressions. We believe in Finland that it's long due to learn more about the needs of the Nordic indigenous peoples, what they are and who they are, as collective holders of distinct traditional knowledge and cultural expressions. In the Nordic countries, we share the Sámi that live in Finland, Sweden, Norway and Russia, and the Inuit in Greenland are formally part of Denmark, although they have self-governance. The Inuit people live across the Arctic region, making this also an issue on the Arctic level, Canada, United States as well. We believe that foremost, this is a Nordic issue. We have common Nordic values, and functioning networks of cooperation. We might also include and consider in the future local communities' issues, such as the ones in Faroe Islands, for instance. We want to make intellectual property or intangible properties, intangible cultural heritage, a source of empowerment to the Nordic indigenous peoples and local communities, and make this a common, widely and openly debated process. And we are all here to understand better what the types of TK and TCEs there are, and what kind of external use is needed, and what kind of external use is, needs to be fought against. Good morning once again, also for you who are online. We want the Nordic countries to provide a supportive atmosphere and to increase trust between the Nordic indigenous peoples and the government, to be there for these peoples in their attempt to fight for their future, identity and livelihoods. Now we must acknowledge that this issue has been negotiated at WIPO level for almost 20 years, but the advances have been small so far. I believe this is due to the lack of profound understanding of what the basic concepts of indigenous law is, which must be put to the center of attention. At WIPO, indigenous people are observers and not part of the formal negotiation or the delegation of WIPO member states. So how can we drive this issue on EU level or Nordic level? Maybe to increase our understanding among the Nordic countries who are members of the European Economic Area and have knowledge and often also formal obligations to take indigenous issues into consideration. The Sámi are the only indigenous people in the EU. This is something that raises expectations for action. But let me take you back some years, when I first encountered concrete problems presented in the keynote, for instance. It was in 2006, during the Finnish EU Presidency, and at the IGC of WIPO, the Intergovernmental Committee on Genetic Resources, Traditional Knowledge, and Traditional Cultural Expressions. This was virtually the first time that I encountered the issue of Finnish Santa Claus land and the misappropriation taking place there of the Sámi culture. First time I understood that it connects with my area of expertise. I also heard issues to the contrary from member states saying, and very convincingly, such protection will never be achieved, and the emphasis was on never. This was devastating to me. I felt that such an environment would not promise any tangible results in the near future. Then I saw a written text on the wall of Le Scandale in Geneva. The text was in French, and it said, "Le contexte est plus fort que le concept." The context is stronger than the concept. I felt that this text tried to tell me that the concept of indigenous people's rights were a concept less valued in the context of the protection of intellectual property. Or maybe the concept was just not known. Meanwhile, in the Nordic level, Nordic Sami Convention was developed between Finland, Sweden, and Norway. This instrument had in its final version 9 references to traditional knowledge. It is yet to be implemented. Later in 2015, there was a fallout at WIPO level, and a mandate could not be renewed. This provided an opportunity to reflect on a next step. What should we do? And we did. We decided strategically that we increase the awareness about the Sámi people beyond the EU countries to WIPO member states in general. We wanted to ensure that the rights of indigenous peoples also are shown within the context of industrialized countries, for instance. In 2017, the Council conclusions of the European Union on the UN Declaration of Indigenous Peoples' Rights pronounced that the EU should also support the protection of indigenous rights. EU countries should protect the rights of indigenous peoples. So we felt that there is a possibility to take this issue closer to the source, closer to Sámi people. But we also felt that we need to have a better understanding on the national level. So we started to build expertise, try to connect more broadly on the national level. And we formed a traditional knowledge network in Finland. So between the governments, the respective ministries, the Sámi parliament, representatives from different areas. And we found out a way to keep in contact. Since then, we have been able to follow the work of the Sámi parliament better, and we can be informed by it. So finally, how to come to the present time, how can the Nordic countries assist? Instead of trying at first instance to find a text-based definition on international level about the subject matter called traditional knowledge, so far from the source, in our case the Sámi and the Inuit, we could listen to the Sámi people's own emergent view on what the subject matter is and what it means for the people and their identity and their livelihoods, including future generations of indigenous peoples, and what the external uses cause to them. We must also embrace the work that has started and is a common 3-year work plan of the Sámi Parliamentary Council. So we should first listen, and then listen a little bit more, and then ask clarifying questions. At this stage, this is not a negotiation. It's an occasion to develop human understanding. Exchange of information and experiences to forge a dialogue, not only on the substantive level, but also on the political level. And we must also provide practical facilities for this cooperation and increased knowledge and the dialogue to take place. Let's just get acquainted with each other. While I would not like to mention this in specific detail, and I have mentioned WIPO and IGC a few times, we should not mix up this work here on regional level with the work going on in the IGC. These processes are separate. They might inform each other, but they are separate, and they can only, the regional level work can only provide concrete input and experience and evidence to the international level. So by these words, I'd like to welcome you once again to the conference and invite you to a dialogue to continue over the years to come. Thank you very much.
Harjan kiihti Anna Puori outtasparko outtas tämän konferenssa plänemis. Ja muut oikein. Täällä miikulla tervoa tai tavirihkalas ministeriäs Rädis toppelea Paula Lehtomäki satten mitchie filmatervuoda.
Your Excellencies, ladies and gentlemen, warmest greetings from Copenhagen to Inari, where I have heard winter has already appeared. I am very pleased that the important themes of immaterial property rights of indigenous peoples are being raised in a Nordic context. I would like to thank the Finnish Presidency and all who have contributed for taking this initiative. Issues related to the protection of traditional knowledge and intellectual property of the indigenous people are closely connected to environmental as well as economic and social sustainability. Thus, they are well aligned with the vision of the Nordic Council of Ministers to be the most sustainable and integrated region in the world by 2030. Today's topic concerns several Nordic countries and benefits from being looked upon jointly and similarly across borders. Indigenous cultures are vulnerable and need protection, otherwise we stand to lose them. It is important that the indigenous people of the region, the Sámi and the Greenland Inuits, can manage and benefit from their cultural heritage, traditional knowledge and intellectual property. This work is linked to issues of biodiversity, sustainable production methods, cultural diversity and inclusion, work against climate change, economic revenues and terms of creators, etc. So there are many aspects to this and many parties that could and should be involved. It is important that the indigenous people are active in this work, but it is decisive that we, the others, and the institutions of public power are committed. One of the key challenges is that we lack understanding of what traditional knowledge is. We lack understanding of the cultural heritage that needs to be protected. Also, in this regard, today's conference is of great importance. Ladies and gentlemen, within the work of the Nordic Council of Ministers, indigenous traditional knowledge and intellectual property are addressed in many ways, although we don't have any framework or working group specifically connected to them. In the Nordic Cooperation Programme of Cultural Policy for 21-24, the ambition to bring cultural heritage to life and to promote inclusive and innovative Nordic art and culture is stated clearly. This should be done in a way that strives to a green, competitive and socially sustainable Nordic region. Nordic culture ministers underline the role of the arts and culture in promoting sustainable development, including the importance of taking into account the specific traditional knowledge of indigenous peoples. One basic premise is that everyone shall have opportunities to participate and exert influence. This means that indigenous people should be able to manage and benefit from their traditional knowledge and cultural expressions. Empowerment of indigenous people and national minorities should be emphasized. The Nordic Council of Ministers has for a long time supported Sámi cultural cooperation across borders. The funding to the Sámi Council and the Sámi Artists Council helps strengthening Sámi cultural cooperation across national borders in the Nordic region. This is important for visibility of Sámi art and culture and strengthening Sámi identity and community, and not least for supporting the preservation of Sámi cultural heritage and languages. We also promote the sustainable development of the Arctic with our Arctic Cooperation Programme. There as well, with an important focus on indigenous people. The updated Arctic Programme will be implemented from next year. It includes support for strengthening of collaborative projects focusing on sustainable business and economic growth for the benefit of indigenous peoples and local communities in the Arctic. Sámi culture and traditional knowledge is by nature transnational, and it's therefore only natural to try to find common Nordic solutions in this area. Different perspectives can enrich the discussions and dialogue. And the topic really has many perspectives: organizational, pedagogical, communicational, legal. It thus requires work among experts in many fields and resources on a pan-Sami and pan-Nordic level. The Nordic Council of Ministers is not a legislative institution, but we can act as a platform for dialogue, assist in the development of facts and knowledge, help to create networks and transfer information and best practices. We are eager to understand better this complex issue, and in that way also to find better ways for us to contribute. I also want to stress the importance of including young people in this work. They're the ones with trust to manage cultural heritage and traditional knowledge in the future. Their valuable insights, and not least critical questions, contribute to our common work. With these thoughts, I would like to thank for the invitation and wish you all fruitful discussions.
Jouvatsan, millä tervoda vaippaus arpedi tuossa vaippaus Daphne Sokrafos Jonasson lääkaittusin. Läpur.
Yes, good morning, everyone. I hope you can hear me. Yes? Good. All right, so good morning, everyone. It's a great pleasure for me to be here with you today on behalf of WIPO. And I will shortly start my presentation. I believe it's operated remotely. So if you could please put the first slides on, that would be great. Thank you. All right, so in the 10 or so minutes that I have today, I was asked by the organizers to cover two main topics. So the first one is to talk about the relationship between intellectual property and traditional knowledge, or TK, and traditional cultural expressions, TCEs, and to give you a short overview of legal issues and some of the options for protection. And the second thing that I was asked to do is to talk a little bit of WIPO's work, and in particular, some of the regional practical workshops that we've been organizing since 2015, and to give you a quick overview of some tools and resources that may be relevant. I could have the next slide. So the relationship between IP and TK-TCEs. So it's well known in this audience what traditional cultural expressions are. In very short, they're the various forms in which your traditional knowledge and your culture are expressed. Next slide, please. And then the traditional knowledge in turn is the knowledge which results from an intellectual activity in a traditional context, and it can be relevant in various specific technical fields. Next slide. Now, what's really important in the context of discussing the relationship between TK-TCEs and intellectual property are some of the characteristics of TK and TCEs, what makes them knowledge and expressions that are different from other knowledge and expressions. So the first one is that there is an element of time, because usually they're transmitted from one generation to the other. But that being said, they're not stuck in time because they're constantly evolving, developing, and being recreated within those communities. Often also, we don't know really who the author is of the pre-existing cultural expressions and traditional knowledge, and they're seen as belonging to the community as a whole. So there's like a communal element to them, although obviously for the contemporary expressions of the culture, for those we would know who created them and who is their author. just to finish addressing the relationship between TK and TCEs, is that traditional knowledge and cultural expressions are intellectual property because they are creations of the human mind. But because they have these characteristics that we discussed, because of the fact that they're traditional in nature, they cannot sometimes be fully protected by the existing intellectual property system due to inadequacies of the system. So there's some gaps in existing IP protection that fail to protect TK and TCs adequately. And for those reasons, a number of countries and regions have opted to adapt their IP laws to take into account TK and TCEs, or to create new sui generis regimes. And in the full presentation, you'll see a link to a database that we have that show you examples of some of the national initiatives, but also regional initiatives to give additional protection to TK and TCEs. And I think that this can be informative in your context. Now, Anna already mentioned the WIPO IGC, so I'm not going to talk about that. But the WIPO IGC is negotiating the terms of the sui generis, a new type of legal instrument that would address specifically TK and TCEs. Now, that being said, existing IP rights are also useful because, in particular, in the context of entrepreneurship, they play a key role in helping entrepreneurs to build stronger and more competitive businesses, and that's both for the protection and promotion of TK and TCEs, and these should be taken into account. Now, moving to the regional practical workshops and some of WIPO's work in this area. So now, if you could go to the previous slide, please. Since 2015, WIPO has organized a series of regional practical workshops on intellectual property, traditional knowledge, and traditional cultural expressions. These have taken place in the region, and we've had some for English-speaking African countries, Pacific countries, South and Central American countries, French-speaking African countries, Asian countries, and Arctic countries in 2019. And to that last one, there were participation from some of the Nordic countries as well, and some of Sámi representatives. And if you can have the next slide, please. So the objectives I'm just going to say a few words now on the objectives of these workshops and who participates in them, what are some of the key features, outcomes, and the fact that we have a report. So the objectives, in short, and I'm conscious of time, the main objective is to foster cooperation between government officials from various departments, so IP government officials, but also government officials from other relevant departments, and indigenous peoples and local communities within each country, but also between the countries of the region, because there are some commonalities between countries of the region. Another objective was to impart basic knowledge of the main principles, systems, and tools of the IP system. That's mainly for indigenous peoples and local communities participants, and how these related to them. And we tried in those workshops to emphasize both the potential value that intellectual property could bring in support of the protection of traditional knowledge and cultural expressions, but also the challenges of doing so. And finally, a very important objective is to facilitate the country level exchanges, but also exchanges on experiences, best practices that are relevant to the protection of TK and TCEs. If I could have the next slide. So who participates in these workshops? As I mentioned before, government officials from IP offices and other relevant departments, and an equal number of indigenous peoples representatives from each of the countries that are invited to the meetings. And WIPO supports the participation of indigenous peoples by financing their participation and helping them travel to the location of the meeting for the duration of the meeting. Usually we have a first day that is dedicated only to indigenous peoples in order to cover some information on intellectual property generally, but also to give them the opportunity to to meet amongst indigenous peoples from the region and discuss really what are their objectives and their expectations ahead of the meeting with everyone, with the government officials as well. Now, usually there's no necessarily outcomes of the meeting that are expected, no formal decisions, but there is a report of the meeting, which is usually very useful to be able to keep track of any recommendations and any important discussions that came out of the meeting. Now, if I could have the next slides, please. Yes, and here, I think to conclude, I included a photo of the practical workshop on IP, TK and TCs for countries from the Arctic region that took place in Iqaluit in Canada in May 2019. Next slide, please. And I think that's it for my final slide. So thank you very much for your attention, and I would be happy to answer any questions related to WIPO's work or these practical workshops. Thank you.
Kihtu tapne. Mun lohpiin iskahtahkahtan jouvas outapukti maingelaskilliin. Täällä. Niin. And then we have one of our own Sámi experts, Matias Oren, PhD, Faculty of Law, the Arctic University of Norway, presenting a legal perspective on the topic of the day in his speech, Indigenous Peoples' Cultural Heritage and Right of the Self-Determination. Audience will have possibility to ask questions in the end of the day in Q&A sessions. You are welcome, Matthias.
Okay, can you hear me? It's okay? If so, could you please put the first slide on the screen? Yes, thank you very much. Addressing Indigenous people's rights to self-determination with respect to cultural heritage presupposes an historical flashback. I will thus begin this presentation by saying a few words on colonial law's take on Indigenous peoples and on how the decolonization process impacted on international law's understanding of people's rights in a way that would have profound consequences for the international Indigenous rights discourse. Subsequently, I will then turn to the main address, the contemporary right of Indigenous peoples to self-determination as it relates to their cultural heritage. So, starting with the colonial era. International law took an interest in Indigenous peoples from the outset. This interest was, however, not to engage them in the international legal project, quite the opposite, to be frank. The aspiration was to exclude Indigenous peoples from the realm of the law of nations. For this purpose, the terra nullius doctrine was constructed, proclaiming Indigenous peoples too uncivilized to carry sovereign or any other kind of political rights that we today might consider self-determining. This proclamation was necessary from the vantage point of the law creators, as the ambition was to declare colonization lawful, and since one cannot really justify colonization of an equal. The terra nullius doctrine consequently declared Indigenous peoples without rights, including with respect to their cultural heritage. Colonial law would reign supreme for about 3 centuries, thus demonstrating that the law is a more effective colonizer than military force. This order, the described one, was really challenged only following the establishment of the United Nations and the gradually crystallizing contemporary human rights system. Now, the right to non-discrimination and principles of equality emerge as fundamental building blocks in international law, rendering continued colonization untenable. because the principle of equality between peoples required the colonization and an equal cannot determine over an equal. A principle of equality between peoples thus replaced the colonial order. And equality between peoples in turn entails that peoples hold equal rights, including to self-determination. Otherwise, they are by definition not equals. So, in sum, the decolonization era established the basic international legal premise of equality between peoples, encapsulating equal rights of peoples to self-determination. Factually, this decolonization process bypassed indigenous peoples. Still, the legal principles developed during this era would prove to be of cardinal consequences to them. And here you can shift the slide. Thank you. Because when the international community belatedly addressed the situation of indigenous peoples in earnest some decades later, it resulted in international recognizing them as peoples, thus also for international legal purposes. And with this acknowledgement followed, consonant with the just outlined law of the decolonization epoch, the more specific recognition of indigenous peoples as peoples equal in rights with other peoples, and thus as beneficiaries of the right to self-determination. And this became reflected in a multitude of international legal sources, including the UN Declaration on the Rights of Indigenous Peoples, jurisprudence from the UN treaty bodies, such as the Human Rights Committee and the Committee on the Elimination of Racial Discrimination, case law from regional human rights courts and commissions, extensive state practice, and so on. Please change the slide. So, that indigenous peoples are peoples for international legal purposes, bestowed with the right to self-determination is no longer an issue and not debated. What remains to be resolved then is the nature, reach, and content of this right, an issue, on the contrary, which has been and is subject to much debate. But this debate could come across as puzzling, however, against the backdrop of the fact that the nature of indigenous people's rights to self-determination is spelled out, black on white, in the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights, Common Article 1.1, and UN Declaration of the Rights of Indigenous Peoples, Article 3, and these three provisions share the same second sentence which appears on the screen. And here we can forget about the part saying freely determine the political status, as this concerned the external aspect of the right to self-determination, which is not relevant here. So setting that aside, the rest of these provisions proclaim that by virtue of that right, that is the right to self-determination, they, that is indigenous peoples, freely pursue their economic, social, and cultural development. This is indigenous people's right to self-determination, pure and simple, stated here in this sentence. It follows from, in addition to these just cited provisions, the treaty body and regional human rights institutions, jurisprudence I just mentioned, and the principle of equality between peoples established during the colonization era. And relevant to this particular context, indigenous people's right to self-determination, that is their right to freely pursue their economic, social, and perhaps in particular the cultural development, obviously capture a right to develop their cultural heritage. So this is the material scope of the right to self-determination. What is then the temporal part? Here, one must again be mindful of that the indigenous rights discourse can only be properly understood in an historic context. It distinctly embeds a form of belated decolonization. It includes a remedial aspect as distinct from being simply forward-looking. Indigenous rights are at their core about providing indigenous peoples with opportunity to preserve and develop their distinct societies, cultures, ways of life, and ultimately their very identities. This purpose can impossibly be served by only forward-looking rights, disregarding everything that occurred before the emergence of the international indigenous rights discourse, which happened about the same time as the emergence of Reagan, Thatcher, and the Pac-Man eras. Consequently, the remedial component is salient in the indigenous rights discourse. This is, for instance, reflected in the Committee on the Elimination of Racial Discrimination, having identified indigenous peoples as epitomizing victims of structural discrimination. And structural discrimination refers to discrimination occurring today, but which is a result of structures built into society in the past. Colonial law might have been erased, but the societal structures it produced could still remain, and in many instances does. And the indigenous rights discourse is very much about deconstructing such structures. Similarly, with respect to lands and resources, the right to restitution have gained significant traction recently, as reflected, for instance, in the Declaration of the Rights of Indigenous Peoples, Article 28, as well as in the Committee on the Elimination of Racial Discrimination and reading the Human Rights Courts and Commission jurisprudence, and as further highlighted by the International Law Association. According to this right, indigenous land rights embrace not only lands and resources historically and continuously used, but also lands and resources historically used, but at some point in time lost by no fault of the indigenous peoples themselves. The same principle reasonably applies also to cultural heritage of the intangible sort, irrespective of that international legal sources to that effect are not that explicit yet. In short, international law does not allow reliance on the apologetics of the law. The colonial era between 1648 and 1980 cannot simply be fought away. Rather, indigenous people's rights to self-determination, that is, the right to freely pursue their economic, social, and cultural development, embraces elements of their cultural heritage, including intangible such, which indigenous peoples lost control of before the rights as self-determining peoples were recognized and operationalized, as these were lost by no fault of indigenous peoples themselves, as they were then still subject to colonial law and thereby incapacitated. And can you shift the slide, please? So, finally, factual circumstances compel me to end with a few words on that the right to self-determination must not be confused with a process. As seen, an array of uncontested international legal sources explicitly establish that indigenous people's right to self-determination is a right to freely pursue their economic, social, and cultural development. Full stop. For some reason, though, the debate on indigenous self-determination has come to forget that this is the de facto right, instead becoming sidetracked by a complete or almost complete focus on process. And more precisely, the discussion has become one of whether the right to self-determination of indigenous peoples is a right to consultation or a right to consent. And this is the case, and this digression has occurred, irrespective of that, as seen, international legal sources make it abundantly clear that it is neither. Again, these sources establish that the right indigenous peoples are bestowed with is a right to freely pursue their economic, social, and cultural development. That is the right. And this right might then be operationalized by a process. And which process one opts for is not that relevant in itself. It can be one of consent, it can be one of consultation, or it can take another form, including a game of dice. The law only requires that the process, whichever one opted for, effectively implements the right to self-determination. That is, in the case of the Sámi people, the right to freely pursue their economic, social, and cultural development, including with respect to their intangible cultural heritage. The signed Nordic Sami Convention, mentioned a few times already today, misses this elementary point. Instead of prescribing that the purpose of the process is to realize the right to self-determination, the Nordic Sami Convention provides that the process is the right. According to Article 4.2 of this convention, self-determination is exercised through consultation. The Nordic Sami Convention, in other words, substitutes the right, which is found in the preceding Article 4.1, with a process. And a comparison can here be made with the Declaration on the Rights of Indigenous Peoples, Article 4, which provides that in exercising the right to self-determination, Indigenous peoples have the right, then it proceeds with permanent self-government. That's not important here. So the declaration, in other words, identifies a process which can further the right, which is found in Article 3 to self-determination. It does not, as the Nordic Sami Convention does, mistake the process for the right. The formulation of the Nordic Sami Convention on self-determination is unfortunate if the intent is that the Sami people have no less a right to self-determination than do other indigenous peoples. Thank you for your attention.
Kiitos Matias. Okta tehalas oassi konferenssaille maita ähpävirkkalas servostalla ja teivät ja mi. Nuupa mit olla täällä kaafepottu. Mi nohka pel koktenupelohkai kaska Eurooppa aikis ahte pel okta Suoma aikis. Ammal miilä pohka harjanan jo korona-aikkin servostalla torvolatja. No. Please have a coffee break, safe, but meet new people. It's one of the most important things in these conferences. Thank you. Toivomus olemme mai kaittusin lä pahta rohtulotta sattaa. Kähtsä sattaa jouvovatsa kulla norkka saametikki päällis Silja Sompy ja Pia Nuorkam. Soi outan puktipa imkas outa kielekatusa millä tahkon Sami parlamentaaralas programma vuodol. Lähki puori Silja ja Pia.
Joo, ollut kiihtytänots. Puoli holmot. Mulla on somban maari Silja ja parkan räddeaddin saametikkis norkapäälle. Mulla on parkan kähtin ja suotselan asion kueftemlottua kuutambloträes, kun älken tokku parakui. Okta suotselan vuolkasatsilla lämmus UNESCO kueftetuot kolma konventiona immateriaala kulttuurarbi kähtämä härräi. Maittai tanniko suotselan strategia parkut är herra viippos, äillä houtana nu johtille ko alkualmoilla saavan. Olahan tihti suotselemme Sámi arbetiedus ja immateriaala kulttuurarbis. Lää takkar parku, kos oftuhi kuorra pälkä, mii suorakasa tuok teihke. Sámi päälle sväsi, että äillä tuarvai naftsat ja olma puhlaan pälkäi kuorrakohtit. Nu lähe Sámi lohkunäpmi tai äsitä oppalas lohkunäpmi. Tansaisko sidret, arbetiedu, immateriaala vaikvuodai, immateriaala kulttuurarbi, tai arbivirulas oudan buktan vui. Temi kähtstai deu oktan. Takkar oppalas tai hulistelas lahkunan vuohki. Lämai vuovas alkualmot kähtsän kuoblus ja heive vuohka seppo Sámi jutsjämmäi. Kuefti tuo kolme konventiona barku läi taadistaa Botniasan takkarkuului, koska kiehtsadi muudan konventiona saatsi kievohi äyhkin, voi saatsim olahit iesmärrilämme tämän suotselan darabui ja barkui. Maittai immateriaala kulttuurarbi Saamis imkas ouda projekta barku lämmus naana läitstäji olla palkstjugi. Imkas ouda projekta vietsäji vuodu SPR doimaplanas mi mangmust merrui danjoja alkus. Ja ulimilhan lää häppä hoktsas Sámi lahkunämme Sámi kulttuurarbi ja arbedihtui ja vuodulittan suotselämme tarpui ja metodai. Merradus lää SPRstä olla suhtit Sámi iesmääritämme ja perräikähtsi kulttuurarbia arbetiedu pähtäiki. Kärtet Sámi laakaprinsippai, mahtaaset ja vuodu kulttuurarbia arbetiedu haltsämis. Kärt Sámedikki iesmääriä noinui ja vel oktsas juurtsemi. Kärt aasi, koska erenamstarbu oktsas politiikkallis juurdei, numma herää tuskan tähän erädoimat, lassin rihkaikaskasas laakaprosesseide. Mihtula olehi oktsas politiikkallis vuodu läikaajaldaide. Määrädus läämaidei sohpat oktsas politiikkallis vuodu olahan diiti iesmääritämme. Ja hämmet oktsas strategia ja hämme haltehuslas aasahuusa. Ja maidei semmäs hämmet haltsan prinsippai. Ja Sámi parlamentaareras räävi toimaplanas, te sillä efterhand att si toimi Tanjalain att vuolkeit of the kolmajaje projekta, maslistju politiikalla styyrin joukku, lassin pargojoukku ja masvella mandaatti vielä holkupäällä kelpulas vuoda tarpumelde. Imkas ouda projektalla buorimuutui, mai tjäjä tjuujua sammakuului, mutta hastalla mai semmäs dan asperra toimaplana. Ja imkas ouda projekta avjuhus lähkä, että mi tarvitset tjelläkö politiikalla oinnu ja politiikka Sámi immateriaali kulttuurarbi ootmalaide. Ja että mi färt hukset struktuurellas toima. Vi färt fuola i resurser rotalan bargui ja bargidafus, vuhanda resurser gajallat. Semmäskö ouda nahti struktuura huksema, barguvui ja toimahi ääsi. Lämai darbu koordineer Sámi almua politiikkallis liittuvan positiona, rihkaikaskasas instrumenta ja nationala laajherrai. Perre gert skolehallama, koordineerima ja struktuurai Sámedikki-kaskas. Ja perre gert spargui mahla vuolkaa huvun ouda projekta aikulas. Projekta kallega bit vuodu ja tseg ruuda kuhki häikki tjovulämmäi. Ja nu lägger det här imkasprojektet lämnas oessin den Sámedikki-barkus ja Sámedikki lägger norkabällä Sámedikki lämma i dakan politiikalla smärradussa tievas tjahkin märradusan kueftelöi ofta gäsemanus. Ja den ässinamma lägger Sámi immateriaali kulttuurarbi uomastämi. Ja nu tahtui mai tjovulitan että dat projekter dat tjovulla maittedan projekteraporta avjuhusa siskarastit bahtaiki Sámi immateriaali kulttuurarbai. Ja nuota tässä Sámi kulttuura kuotas oessin ja että säilyha ja dan säilyn maittai Sámi haldus nuot Sámedikki nannes Sámi ja rifti ja principai Sámi immateriaali kulttuurarbis ja dan gieva hemes. Matbot herra oudan den valtisni ja Sámi kaskasas oftspargo sietadus. Ja tievas tjahken määräys läjällä, että Sámi individuella ja kollektiva kulttuura nuo esteettalas elementit, musiikka, kielä, mainast, historia ja era arbevirullas kulttuura oudan buktimat läh ootmodavat ma kuulle Sámide. Ja Sámedikki kalga juhkit Sámi immateriaali kulttuurarbi prosessa ja ohtsa vui ja toimabiu ma säht tust hastalusai ja darbui ja obdide riifti kuulevats immateriaali kulttuurarbi uomastämäi. Dievas tjahkin määräys lää maittai, että Sámedikki Sámi immateriaali kulttuurarbi prosessa ohtsa pähkäläs nationala miehtä Sámi ja rihkaikaskasas parkuvui nan ja huks Sámi immateriaali kulttuurarbi uomastämi. Immateriaalis kulttuurarbi rastilla njälje rihkarai ja tanne berda koordinerijuhti ei rihkaikasks. Tanne färte SPR involverijuht ja nannijuht voi alkualma farolaipes määri siinkuovlu ja päihkikotti oudanemi. Mikal kiedja sihkarastit, sihke materiaalelas ja immateriaalelas kulttuurarbi ja min asama ja kulttuurtoima vuodu. Materiaalelas ja immateriaalelas kulttuurarbilla sorjavats ja tai ferte gähtsch oktaladjan. Tai gähten fertila nanus ja dan ferte Sámi almut stiudet. Nano saamas kähtän fertillä vuoduntaan viidesit parkui muuttulee sorjuvastas, että saamedikki adju tuota vaihkuan veilusuoda siiski prosesseita ja kähtämiä. Ja vielä liidat määrädusmi puoli saamedikki diavastuakin olisi. Ja millä täällä kähtän tai kolma ieskuudekke millä kähtän siiski että tämän SPR-määrädusa ja mailla imkasprojekta avtjuus ja väl tämän, että mo saamedikki diavastuakin la jälkändan. Omastamme jälkämus saamedikis lassin SPR doima eftuus jälkämusa aasahin mekanisma palkstjovka samma kuului. Sammas, kun päivä alkuu julkaistus, olla saamedikkiradis jälkä tahtu tegt aasahusla sroftu, masla arbidihtu ja immateriaala kulttuuriarbiharrai. Te saatsi juutsis kuhtit, että saatsi ei aikumusai chaski okti. Mutta taas tapsu sieras joulan strategia, kosmi kähtsmu saami päälle saatsimme tuotandak, iäjämä iäsmääritän välti tai äsi härräi. Ja tano oktovuodesta liittyy hui tehdä, mi tjohksistimä päikki kotiin ja lyhtävä sovtsteji, arbedehti, aasahuusai, saamedikki, organisationai, puhutai rihkain, kun saamit ääst. Ja tuolla siirrä tjohkima, tai tjohkin tilalla suoda, kos mi pääsi iäjä tjohkani ja saastalla kuat, tai hastalusai birra ja muodai tjoudit. Mi shottuuske tämän päälläkään todista kuorrat, mutta tällä purimuutui tjelkanatella hui mohkas toima. Ja että kaskhaari ferta aips olla päälläkämä alkahit. Mutta tällä haalan vähän metaforen, tällä vähän takkara hastaläji parkulet. Mutta just den algorien mun haalien kiihtit ja januasis ja kiihtä mai podiumus pesteikä saastille. Ja täällä vara Pia on juotkat viidestän mun oktsas saakkavuorus.
Parre päivi puhkaita. Hello everyone, my name is Pia Nuorgam, Uopti Ovla Silja Pia. I'm a Sámi lawyer from Utsjoki, and when I started working with these questions 20-something years ago, no one was really listening us Sámi. It was mostly young people then, and now too, that were talking about problems of cultural appropriation publicly. When thinking about that, it is quite amazing that Nordic Council of Ministers, Nordic governments and IP offices have gathered to listen and discuss this matter. So I want to thank the Nordic governments for your support, and I especially want to thank the Ministry of Culture and Education in Finland, and Anna especially, from pushing this matter forward, and the Sámi Parliament in Finland for prioritizing this conference. Thank you to my project colleague Silja for summarizing the background and results. As Silja, no, can you please go back to the, yeah, thank you. As Silja described, IMCA's project was designed to explore the landscape on the matter in Sápmi. Our starting point was internal needs and values instead of external definitions on subject matter. Like Silja said, holistic approach. But if you use the traditional definitions in this area, in the project we mostly looked at Sámi cultural elements, or as we called them, cultural resources or intangible cultural properties. These elements are vital for cultural identity, and they are building blocks of the livelihoods of the Sámi. And in fact, there are legal principles and rules on the use and hence control internally. We also found out that these rules actually mean that there are levels of ownership to the different elements. When you grow up in Sámi culture, you learn to know these rules and you learn to respect the boundaries of this collective ownership. As an example, we have strict rules on our beautiful dresses, including how they look, what messages they contain, when to wear them, and why to wear them. Today, I'm unfortunately breaking one of those rules, and so feel the need to express to you in words the respect I have for this place, gathering, and each of you being here. Knowing so personally the rules and law around our cultural elements, unfortunately, sometimes makes each Sámi individual the gatekeeper and protector of our collective identity and properties. Because these elements are so vital, we recognized that risks of appropriation or even projects with good intentions are huge, and we need to find solutions to strengthening, management, protection, and beneficial use of these elements. Otherwise, the end result is that we lose them gradually and at the same time what makes us us. That poses a huge risk to our people. At the same time, another risk is that there is not enough support to keep these traditions living and breathing and visible in society. To see what has been done already in this field, we mapped the actions and policies of Sámi parliaments and other actors. A lot has been done, and there are even laws in place that actually recognizes the Sámi ownership and allow control. One of the best examples of this is the Norwegian law regarding genetic resources and TK, which implements the Convention on Biological Diversity and so-called Nagoya Protocol. There are also attempts on trademark protection, guidelines and ethical rules, which all indicates to us that there is a need and desire to find mechanisms of control, and hence that confirms the idea of ownership. But what we also found out, for the control and protection to be effective, we, the Sámi, must have more coordination at a collective level. We lack that Sápmi-wide coordination. Most effective and efficient would be to have a central Sámi body to deal with these issues, a point of contact for the Sámi, ourselves, and the outside world, and with the ability to manage and develop these rights, and also the ability to enforce Sámi rights against others if necessary. We say that one central body that uses human rights-based and right-based approach seems the best option because we tested it. We used that kind of mechanism with Frozen 2 collaboration and with many questions we got during IMCA's project. These questions were mostly from Sámi actors, the gatekeepers who needed advice and desired that we could lift the burden of being the gatekeeper from their shoulders. We have seen that not lifting this burden from the individual to the collective level and collective institution often places great pressure upon our artists and creatives to the point of limiting their artistic freedom. As an example, there is a lot of good and needed developments of different types of media products for Sámi kids. These obviously need to be based in our culture too, yet we often lack of expertise in creating this media, such as computer games within Sápmi. Thus, Sámi actors often need to seek outside partners to make it happen, but we often see that these cooperations come with contracts where the end result is owned by the external partner. So the good intention to have Sámi language culture-based computer game might end up with being owned by someone else, and that someone else leaves Sápmi with a contract and collective property in their pocket. In this project, we encountered just such situations and helped the Sámi actors and gatekeepers to make sure we still own our culture after a cooperation with external partners. And when I say we, I mean we as a people, but also regional owners of certain elements. So in this project, we were looking after the interest of not only the collective name and reputation of the Sámi in commercial world, but also the smaller groups. As these types of collaborations become more and more popular, there is a real risk of internal conflict because of our layered property and ownership. Without a Sámi-wide coordinated approach, it is possible that individuals or sections of society can allow an external partner to walk away with another region's and group's heritage with no control to use afterwards. Such an issue was seen in the sun symbol situation. We need to discuss and clear the boundaries for the benefit of our own people. During the years, we hear a lot of people questioning commercialization of Sámi culture. Many say that cultural values and economic aspects work against each other, and that earning living out of our culture might destroy cultural and spiritual values. I believe we can make informed decision on what we share and what we don't, if we want and if we have control over these elements. Also, I believe these things are not in conflict, but instead the Sámi people can use economic value to motivate keeping our culture living and breathing. With trademark and property protections, we can give our entrepreneurs and, for example, handicrafters benefit on the market. When you can make living out of your culture, I think that is good motivation to learn, revitalize and develop it further and keep industry and people in Sápmi. Reindeer herding is definitely the one cornerstones of Sámi culture. Reindeer herding carries a lot of TK, cultural and spiritual values. But we could ask, would it be so strong if you couldn't make a living out of it? We also understand the Parliament's prioritizing important matters like language revitalization and educational rights and linguistic rights of our children, and how the Parliaments want to, for example, combat hate speech. Very important. But I must say the work with enforcing IP rights of Sámi can support those efforts, because many of us saw and experienced how getting frozen on the same day than the Nordic languages, and the fact that we were visible in the film and Sámi recognized that, lifted and motivated our children to speak Sámi. And the adults that usually are hesitant to show their Sámi identity to do so. In this, I experienced Frozen brought us to another level as one of the actors in society and detached us from hate speech. It was through the position of recognizing and respecting Sámi ownership of Sámi cultural property that we were able to achieve such a result. I also doubt that we could in the near future force private sector through laws to offer Sami language media catalog, films and games and magazines in Sami language. As a mother of 2 children, I know how important getting the popular content in Sami language is. Through this kind of work, it might be more than possible. Only Sami control over our property and recognition of that ownership and control can provide guidance in such situations. We have seen so many examples of outsiders' appreciation of our culture, or in their mind, legal inspiration, that is actually an improper use of our property for their benefit. When we get requests for guidance, often we cannot afford not to answer, because not to offer guidance, we then leave them the power to make decision on the interpretation of the content of our self-determination. Non-Sami do not have the experience or understanding to know how to respect our rights without us telling them. It is through our properties and rights that we can provide guidance and still ensure our culture is protected. We can also ensure that we do not become invisible by empowering and allowing the beneficial use of our culture by our people and their companies by clearing these boundaries and securing our cultural ownership. We have come a long way from people and companies just exploiting us to a stage where we want business development, and the external partners listen and understand our interests. Businesses have become more sensitive now to all of the minorities and also indigenous peoples because of social movements and also development of legislation, such as the Corporate Responsibility Acts, meaning that companies need to evaluate the impact of their actions to human rights enjoyment. In fact, in Norway this summer, the act relating to enterprises, transparency, and work on fundamental human rights and decent working conditions came into force. This is a powerful tool for the Sámi in Norway, and a huge risk for companies not evaluating the human rights impact of their actions in Sápmi. A question remains, can they assess these impacts without us? Evaluation of similar legislation is ongoing in Finland and the EU. We often hear that our culture has no protection, but that's not entirely true, like we heard today. We have the possibility and the right to use the same property protections as anyone else, such as the IP protections in Nordic laws. That is why in our project we talked about rights-based approach. It is true, though, that most of them require activation and us figuring out how to do that. We must also talk about human rights-based approach, which could by one explanation mean turning human rights into effective policies and practices. Human rights are basically rules on how people should be treated. They belong to everyone: freedom of speech, right to education, and everyone has right to own property. These are also right not to be discriminated and people's right to self-determination. These rights also belong to indigenous peoples, like Matthias said in his excellent presentation. Indigenous rights are described to make sure we can enjoy the same rights as others. So we need to figure out what does these intellectual property rights and property rights protection look like in indigenous Sami context. When doing so, the right to self-determination needs to be respected. We need to make sure the procedural rights are guaranteed and implemented. That decision needs to be based on knowledge and the best information available, and it needs to be based on democracy and fair discussion on what matters to the Sami. In order to get to that point, we need the governments, or maybe Nordic Council of Ministers, to support the Sami in this process by providing resources and expert help for us to get there. Indigenous peoples, Sami themselves, need to find out what are the gaps and what is the protection we might need in addition to intellectual property laws that are in place. After all, human rights interpretation demands that our moral and material interests should be protected if we wish so. Human rights-based approach also means that we take UNTRIP 31 article as guidance, as well as the other mentioned rights, meaning we have the right to define and decide what matters and what we work on. I think I stop there. I will just say this. I sincerely hope that the Sami parliaments see their position as the elected representatives of the people who have the right to speak for all of us, but also carry the duty to act on these vital questions. I also hope and expect the governments to support our people on this important task. Thank you for listening.
Kiitos Pia ja Silja Maussala sahkavuorui. Tällä vuorus kommenta sahkavuoru UNESCO Facilitator Harriet Tiikonis. Läge Pore Harriet. The stage is yours.
Well, thank you very much, and it's a great honor to be here at this very important discussion, dealing with issues that I think are quite complex, but at the same time have great promise to be solved and addressed in the future. Could I have the first slide, please? Okay, I'm a facilitator under the Global Capacity Building Program for the UNESCO 2003 Convention. And although I'm not representing UNESCO here, I'm going to speak a little bit about some experiences of safeguarding under the Intangible Heritage Convention. Now, Silja and others have already spoken a little bit about the convention. But I would just say that the convention covers the area of intangible heritage, which is more or less, for the purposes of our discussion, what we mean when we talk about traditional knowledge or traditional cultural expressions. And there are 180 states parties to this convention currently, excluding the Russian Federation, but including the Nordic countries that are represented here. I think what's interesting about the convention is that it really tries to, even though it's an agreement between states parties, it really tries to emphasize the importance of communities managing their own safeguarding processes, deciding what their heritage is, deciding how to manage it, and deciding what can be shared or not shared, and trying to encourage equitable benefit in areas where that heritage is generating economic benefits. And so I think it is of interest in this context to consider some of the experiences around these questions of engagement with commercial activity, and particularly how it relates to IP. One thing that is important to remember about this convention, can you go back a slide? One thing that's important to remember about this convention is that it doesn't confer any IP rights onto communities in regard to their heritage. It really underlines the stewardship of communities, and it respects the rights that communities have at the national level, or indeed potentially at the regional level. So it respects rights that communities already have, but it doesn't confer new rights. And I think here, this is where the importance of regional or national legal protections comes into play. Having said that, I think the difference between sometimes the discussions around IP protection and intangible heritage safeguarding are that intangible heritage safeguarding focuses on the practice, the continued practice and transmission of heritage and its meaning and value to communities into the future. And so IP protection is a tool that can be used for sometimes to promote that. It doesn't really come, often the IP discussions are more about what can you cover and how can you extend the legal scope of protection for cultural heritage in terms of IP. So I think that's really where the slightly different emphasis is in the Intangible Heritage Convention compared to some of the discussions, say, in WIPO around IP protection. Next slide, please. So as Pia was mentioning, in UNESCO exactly the same debate has been happening. How do you think about the importance of protecting ICH or cultural heritage against over-commercialization, decontextualization, misappropriation, and misrepresentation, but at the same time, how do you support communities in benefiting from it? And in the history of the convention, which was first drafted in 2003, there's been, I think, quite an emphasis initially on the risks. And more recently, with the discourse about sustainable development in UNESCO and the UN more generally, there's been a bit more emphasis on this question of how can you find benefits for communities in engagement, and how can those benefits, economic as well as other benefits, feed back into the safeguarding of the cultural heritage. So at the 2019 meeting in Bogota, Colombia, the states parties to the convention requested the Secretariat to develop a guidance note about over-commercialization, decontextualization, and how to address and mitigate those harms. That really opens up this discussion about how the engagement with the market can help to further safeguarding. And I think that this opens up a kind of question about is there a sweet spot? Obviously, there's some areas of cultural heritage that are not appropriate for commercialization. And there's some areas where artists are not earning enough to really keep them going. Is there a point at which heritage-sensitive commercialization actually helps safeguarding? And at what point do communities then decide that this is too much or the wrong kind of commercialization? So these kinds of questions really are starting to be discussed in the UNESCO environment. And I think one of the areas that interests me is, should we maybe think of that spectrum of commercialization from a sort of analytical model? And how do we enable communities to start making those decisions in regard to the UNESCO processes as well? It shouldn't be the committee that decides what's over-commercialization and what's not, which is really sometimes what's currently the discussion. So I'm going to speak about a few examples of safeguarding strategies, particularly in regard to IP, to look at this question of how does one assist the communities to find a sweet spot. Next slide, please. So the first example is a project I've been involved with in India called HIPAMS, Heritage Sensitive Intellectual Property and Marketing Strategies. And this was really a project where we were trying to develop a model of how to think about safeguarding that puts some planning processes in place that communities can use to think about the relationship between their cultural heritage practice and the market, to try and find the sweet spot where they are struggling to do so. So one of the communities we worked with was a group of Bengal Patachitra artists in Naya village in India. And they said they were having a problem with a certain amount of misappropriation, where their designs were being used without permission. And they were also having a problem expanding their artistic practice in the market and controlling that expansion, because they were not in charge of all of their marketing. So we worked with them kind of, I suppose, as consultants. We were a group of researchers in an NGO, listening to the problems that they were dealing with and coming up together with some potential solutions. And I want to make a couple of points about this, because I think it links to this question of how does IP form part of a broader safeguarding strategy. So first of all, on the left-hand side, this particular artistic practice is a practice of singing to scrolls that tell a story. And these scrolls tell all sorts of kinds of stories. They tell disaster stories. In the middle, you see Shwana Chitrakar holding a scroll she painted about COVID and talking about the story of COVID and how it impacted their community. But she also painted a scroll about intellectual property rights, so that she used that in the community to then help to teach other artists about the importance of understanding their copyright. Another artist painted a scroll looking at geographical indications because they had registered a non-GI, a non-agri GI for their art practice. And so the importance of artists understanding about what rights, how to communicate the rights that they feel they own in legal language to third parties was really underlined by this project. And so artists' education on copyright and the GI was very useful in their negotiations with their customers. And particularly in negotiations with galleries or people who wanted to use their designs commercially. So out of that, we also helped them develop an art code where they put down what kinds of problems they were facing in the market and how they wanted third parties to act ethically. And that was attached then to a summary of some of the ethical principles from the UNESCO Convention, which include community engagement and community stewardship of their ICH. We also worked with them on developing packaging that linked their products to their websites and to the songs that went with their scrolls. So that reconnected the singing tradition with the products that they were selling. And this helped young boys to get more interested in learning the traditional songs, which they'd actually stopped wanting to learn because they weren't selling the songs. And now that the songs are part of the product in a very obvious way, it's helped to feed back into the heritage safeguarding. So I wanted to use this example just to talk a little bit about how an IP strategy like a non-agri GI in this case was only part of the broader marketing strategy, where the meaning around the heritage is really created by the artists, and then the IP right supports that in the market. And again, where artist rights are helping the artists to negotiate and protect their interests. Next slide, please. One of the challenges in India was that the artists didn't have the money to go to court or to embark on any really large-scale enforcement of their IP rights. And most of the work that we did with them was trying to make it really operational for the individual artists in their collective organization. I'd like to now just mention some of the work that's being done in Colombia, which I think is very exciting, because this really speaks to the role of administrative organizations, in this case, an organization that's set up by the government to cover a number of different artisan communities and to support them in, I suppose, getting this heritage-sensitive commercialization operation on the market. Colombia raises funds for this through a tax on mobile phone services. And they've also made a nomination of this particular practice, the varnish of pasto, or mapa mapa, onto the UNESCO Intangible Heritage List. So that process has developed a safeguarding plan with the communities who have decided what they want to do to encourage local practitioners to keep this practice going. It was really on its last legs because there were only under 50 practitioners of it. And one of the organizations that the government has set up is this Artesanías de Colombia, which is handicraft people of Colombia. And this organization is run out of government, although it could, presumably one could look at a model where this is run by the communities themselves. And I think some of the activities of this organization are quite interesting. They've done training and capacity building for artisans, for example, rights education or marketing. But they've also negotiated lower trademark registration fees for traditional artisans, so under 10% of the normal cost of trademark registrations. So more than 2,500 individual marks and 60 collective marks have been registered for traditional artisans in Colombia. They've registered 12 craft GIs, including this mapa mapa barniz de pasto, and they've helped communities actually use these registrations, because a registration by itself isn't that useful. You have to market it, and make your customers aware of it. It also pursues various court cases to enforce the different IP rights that it's helped artisan communities to register. It provides an online marketing platform, promotion of the tourism map of artisans. It assists with access and compliance for export markets as well. And so on one level, I think that this is the kind of activity that could assist a community that's developed a safeguarding strategy for its own ICH, and then it could call on an agency like this to assist it in actually implementing the more effective use of the IP strategies. So these kinds of examples are not necessarily exactly translatable into the Sámi context, but I think they're examples of the kinds of debates and discussions and strategies that are being pursued more frequently under the UNESCO 2003 Convention, and they may be food for thought. Thank you very much.
Kiitos Harje. Thank you Harje. Jovavatsa programmas lää porade. Porademi manjel kulla tala immateriaala voika huolai. Suoji vuolkatakai fallan veulasvuolai ja praktiikkalas joutosi pirra norkka patentta toimaha ainus ja maita Helsingin universiteetta tutkiu ainus. Tammanjel lää panella saastallan ja veilasvuohta järra otna päivi sahkavuoroistollin. Mutta täällä porai. No millä muotta minuutta mannana aiketaan vallistu mun tuolla vanhis outapuktima. Jouas sahkavuorolle josten Sandvikis kielä norkka patenta toimahaa päällis muistelemen sinu ainoin. Läke porre justein.
Dear participants, a very good afternoon to all of you. It's a pleasure to be here, and I'm very happy for the seminar and the conference itself. It's good to see myself as a younger person here on the photograph. So, the Paris Convention for the Protection of Industrial Property. Industrial property means patents, trademarks, and designs. Dates back to 1883. At the same time, the famous author Henrik Ibsen lived in Paris and wrote the play Villanden, The Wild Duck, in 1884. Clearly inspired from inventions and patents, Ibsen lets Hjalmar Ekdal express when Gregers Relling asks about his work on an invention within the field of photography. And then Hjalmar replies, as the days pass by, it gets more and more difficult. Everything is already invented. The Norwegian Industrial Property Office receives every year on average 20,000 applications for designs, patents, and trademarks. In addition, we receive European patents for validation in Norway. The rights we grant based on the applications are territorial rights for Norway, and the filing numbers in Norway are small compared to other jurisdictions. An application can be used to go abroad and file applications in other countries or regions. Intellectual property rights are important to secure business positions and investment. For designs, we have the Hague system. For trademarks, we have the Madrid system, and for patents, we have the PCT system. The industrial property landscape is truly global, and foreign applicants constitute 75% of the total amount of applications in Norway. I think we can conclude that Hjalmar Ekdal was wrong. There is still room for inventions. So the Global Innovation Index, which is established in WIPO in cooperation with many other institutions, ranks the Nordic countries very high. Sweden is on the second place, Finland number 7, Denmark number 9, Iceland 17, and Norway number 20. Intellectual property is one element among other important factors in this ranking. The 164 members of the World Trade Organization all have rights and obligations regarding intellectual property, and very important are the principles of national treatment and most favored country. This means that foreigners shall be granted the same treatment as nationals in the respective country, and you cannot discriminate. There are very few examples where a country treats a foreigner from a specific country better than nationals, so the guiding principle is national treatment. Now, for example, the law of trademarks that gives the right holder a sole right to use the mark in commerce has two basic requirements. The trademark in the application must be distinctive, and it cannot be confusingly similar to earlier rights, be it earlier trademarks or business names. In order to process the application, the examiners check encyclopedias, registries, and consider whether the trademark is allowable. Working with distinctiveness includes a strong link to the goods and services the mark shall be used for. Apple works as a trademark for computers and a recording company, but not for selling apples. And since computers and records are different, it was assumed at the time that the marks could be used in the market without confusion as to the commercial origin of the goods and services. The trademarks that appear to meet the requirements of the law of trademarks are published in the weekly Gazette Norsk Varemerketidene as registered trademarks and can be subject to an opposition by a third party. A trademark can also, if it's still registered, be challenged in an administrative procedure before the office and also in court. It is very long, in fact 2,333 years since the legal procedures were kept secret. Gnaeus Flavius publicated legal procedures on Forum Romanum. It has been good law ever since to teach and endeavor to make the law known to people. So the Norwegian Industrial Property Office tries to disseminate knowledge about industrial property rights, and our Customer Support Center has been rewarded with a prize for the best public customer service 3 years in a row. We also participate in business fairs and to raise awareness regarding intellectual property. Now, how can intellectual property officers learn about and address indigenous rights? The answer, as we have heard today, is not given, and questions revolving around the right reply has been discussed for about 20 years in WIPO's committee, the Intergovernmental Committee on Genetic Resources, Traditional Knowledge, and Traditional Cultural Expressions. The committee just had its mandate renewed for another 2 years. So shall we sit back and wait for a global solution? I do not think so. Intellectual property officers should be curious and reach out for insights, and indigenous peoples should share knowledge if they decide to share that knowledge. Many of you know the cases about the Sámi sun symbol in the Norwegian Industrial Property Office. To cut it very short, based on a request for an administrative review, a trademark and an industrial design were considered invalid by the office. The decisions were not appealed. So my advice would be to talk to your intellectual property office and develop sustainable solutions for the local businesses that want to file applications. And with that, I am finished my intervention, and I look forward to any questions that might be from the audience.
Kiitos Jostein. Thank you, Jostein. And tällä Helsingin universiteettä Tuomas Mattila Sahkavuorilla. Lekevuori. Ja mun muistuhan vielä, että tässä programma lohpoosiin lää äiki kasalta, jos pahta tai Sahkavuoro häikkiinnu. Lää varren äiki ahte sahtamaiden järrahtalla. Kiitos.
Yes, hello, good afternoon everyone. Thank you for inviting me. It's an honor to be speaking here today. My name is Tuomas Mattila, and I'd like to say a few words about the basic principles of intellectual property rights and about their compatibility to protect traditional cultures. We can change the slide. And once more. Yes, thank you. So I start with the ownership and intellectual property rights. The big question, are current IP rights, intellectual property rights, sufficient to provide justified legal remedies to those needs that Sámi people, indigenous people have, and to what extent, and if they are not sufficient, what else there should be? And this question should be elaborated, and we should have a profound answer And it's important to notice that even if in some extent the answer would be negative, these are not sufficient, that's also a valuable result, because that could increase the argument that there should be something else, some new legislation, some new regulations. The logic of this process, as I see it, or I understand it, is that where do we want to go? Can we get there with the tools that there is available? And if not, what kind of tools there should be? So first question, what is the goal? Where the Sami people would like to go or like to be? And I took the desired legal state. I nominated here in this slide, but I took from the agreement between Sámi and the Walt Disney Company the objective. I read the part here that is the position of the Sámi, that their collective and individual culture, including aesthetic elements, music, language, stories, histories, and other traditional cultural expressions, are property that belong to the Sámi. That's very clearly said, very clear statement. Now, if we have this objective on frame, let's keep it on the background, I make some intellectual property rights based remarks about it. And the purpose of these remarks is to contribute for this big question, are current IP rights sufficient? Can they take us closer to that objective? So firstly, the question of owned subject matter, what is it that is being owned? And if we think of IP rights, the basic requirements in almost each case is that the protected subject matter must be very clearly defined. There are some exceptions, like laws on trade secrets or unfair business practices, which are, let's say, on the edges of IP domains, but I don't go there. Trademark and copyright laws in particular, they require that the protected matter is defined very clearly. So the question, of course, is to what extent collective and individual cultures can at least partially be defined as individual expressions so that they could be protected by trademarks or copyrights or others. Is it possible to make a list or a catalog or a database of at least most important expressions in a similar manner as Nagoya Protocol and CBD Convention is being implemented? There is the database of genetic resources that is being administered by Sámi. I don't know. I think it might be artificial to think that the whole totality of traditional culture could be archived or put into the catalog. That doesn't sound maybe working. Then again, some of the most important expressions very likely can be defined, this symbol, this song, and they are like definable in that sense. It's of course important for third parties, those who wish to use Sámi expressions, and that like outside users can know what is included in property. If you say, this is my property, that to say what is included there, what is it. The problem with the intellectual property rights here might be, or challenge, how you like it, is that broad definitions such as culture, style, knowledge, all this, it's very difficult, if not impossible, to be protected by IPRs, because it's always the individual expressions. If we think, for example, yoik, the broad category, the musical tradition of yoik as such cannot be protected by copyright, but it's always the song, the lyric, individual expression. And so it becomes kind of like a mechanistic approach to the traditional expressions that you have to like name each one of them. And so this might be difficult. Finally, of this first point, in legal terms, when we talk about intellectual property, it must be noted that often the intangible property is the right itself, not the object. For example, if we say that the Coca-Cola company, Coca-Cola does not own the name Coca-Cola, but they own the trademark to the name Coca-Cola, which then allows them some power to decide on the use of this name on the markets. So in IP sense, ownership could be said that you are entitled to claim by your trademark right those things that trademark law allows you, or copyright. But So if we examine the overlap of these two things, that collective and individual culture are property that belong to Sámi, it can also maybe be read from the point of view of IPR that Sámi are justified to claim as trademarks, as copyrights, with those tools that there exists, those elements that belong to their culture. So let's go to the second point, the concept of owning. That what does it mean that something is being owned if we look from intellectual property framework? Intangible objects, the owning is somewhat different if we think physical properties. If you have a tangible physical asset, let's say a car, you can, of course, you can put your car to a garage, lock the garage, and prevent that anybody can access your car or your mobile phone you put to your pocket. So the possession and ability to decide on the objective's use, it's a key element of ownership in tangible property, in physical things. With intangible things, with intellectual property, is somewhat different because you cannot control its use. You cannot, in the end of the day, control what people, what songs they sing, what symbols they use, because, of course, they can be copied and so on. So in intellectual property world, owning means that you have exclusive right over a certain object to tell other people to stop using it, stop doing that. You're doing something you are not allowed to do. So that's kind of like, we can say, exclusive right, sole right to do something. In intellectual property laws, the ownership, however, is far from total. There's no total control over any object. If we think of Coca-Cola once again, anybody can make themselves a T-shirt which says Coca-Cola or write to their bottle they're drinking something Coca-Cola, say I am drinking Coca-Cola, and Coca-Cola company cannot do anything for that as long as it's private use. If you do it commercially, then of course you are entering to the area that Coca-Cola has their rights. So if we think of so that the owning something consists of certain rights which are then defined in IP laws. In copyright as well, copyright laws can do very little against people's private use. People can make private copies of works. There's educational uses. There are many kinds of uses that copyright law is very limited to use. So there is no omnipotent IP law that would give total control. So if we also look once again, background, objective culture, so on, is property that belongs to the Sámi, it's important to discuss and elaborate what is it meant, what kind of legal position should there be towards this property. If it's exclusivity, power to say to others, you have to have the consent to say no. We see already that there is some limitations to this ability to say no, and how all these conclusions fit into these big questions. Are IP rights sufficient or not? Maybe they are not sufficient for this reason. So then the third point, the owner who may dictate over the rights concerning the intangible property, it's pretty straightforward, at least in legal terms, but IPRs must always have a designated owner, ultimately someone who can go to court and claim this right and file a suit over an infringement. Owner can be individual person, group, company, community, any legal subject. Of course, if we go very into the details, we have to think of I think, legal personhood of the owner of the IPR right. And this is something that if we say that Sámi as a people, they have the subjectivity from human rights point of view, and that's kind of like undisputable, of course. And I think then when that's translated to IPR world, in the end of the day, if Sámi as a people would file a trademark, who would be the owner, Sámi people, how that would be received in the patent office, is the legal person who would require absolute requirement for the applicant, and these kind of things. I think they are solvable, but things that just come up. On practical levels, there are many practical questions that arise, and which I think are being discussed already among the Sámi communities and parliaments and representatives, and I don't have any answers to those. But when there is an owner, Sámi people as the owner, of course, there are questions that how does that translate into the practice if there are different Sámi entrepreneurs, companies who compete on the same markets using the same symbols. If other claims that the symbol is not traditional but their own creation, who can license IPR to third parties, like Pia pointed out on IMCA's report that there should be central body to control all this. Question of individual companies, how big Sámi representation should be or ownership in a company, it to be eligible to have this right to use the IPRs. So very detailed questions, but they're just because it's justified and makes a lot of sense as an argument to say that the culture is property belongs to Sámi, but then we see that this question translates into very detailed practical questions when we try to put it into the IPR framework. So now can we have a second slide, please? Thank you. So second slide, can anything be done with current IP laws? It's a somewhat provocative title by purpose. And to be brief, a very simple answer to this simple title is that yes, something can be done. Is it sufficient? That's the different question. But current IP laws, at least some cases, can offer legal protection. I don't go to very detailed examples here. We can continue in the panel. But for example, there are Sámi Duochi, Sámi made trademarks, which are good examples that IPRs are already used. To what extent they are sufficient, what's their impact on real level, that's topic for another study, but they are already used. And there are internationally numerous examples of certification marks, collective trademarks, how they are used to protect even TCs as such. Some examples, the Navajo First Nation in the United States, already in 1940s, registered as a trademark the name Navajo, and they have more than 60 trademarks in the United States, and they have successfully fought off many clothing companies a few years ago only who tried to use the Navajo name in the clothing. Cowichan Nation, other as well, has registered the name. We heard just about the sun symbol case in Norway, which is in a way like negative example, counterexample, but we see that trademark laws quite quickly reach into the world of TCEs if that's wanted. Another one interesting example, not TCE as such, but like the garment of Mother Teresa, the famous blue and white and blue striped garment, has been registered as a trademark by the sisterhood, Sisters of Mercy, the Mother Teresa sisterhood. It's in India, United States. They have protected it just in order to prevent the abusive use on the markets. I will give some links for the further reading in the end, where are some more examples. But my more important point here is that the usefulness of IP laws, it's not only legal matter. It's quite simple to say on paper, like law in books, what kind of protection for what can be reached. But the usefulness is also a more complex question. There are other factors that must be in this equation. Are IP laws useful? And there are at least 4 criteria I've listed here. And one is, I go briefly around through them. One is the applicability of these laws. Well, firstly, that does IP laws, the eligibility criteria of these laws, do the TCEs meet this eligibility? Like Jostein said just a moment ago, that what is needed from a trademark, we know, of course, words, signs, symbols, they can be trademarks, no problem. Then there are other kind of TCEs, like let's say customs, practices, rituals, and such, which start to go quite far. I don't know if trademark laws go there. Copyright also has requirements. The work must be original. Well, that's legal assessment whether a certain TCE would be original in that sense. Sometimes probably yes, sometimes maybe no. The other thing, like for example, trademarks, you need to use continuously on the markets on commercial purposes. So even if some TCE would have trademark protection, is it used commercially? Would trademark protection then impose commercial use of that TCE, which could go against the whole idea of the TCE? So there is some like a fitting together, which might not always be successful. The second thing, very important, efficiency. Against what kind of protection, against what the protection is being sought? Because now we see already that trademarks are quite efficient on the field of commerce. Somebody tries to do business with it. Okay, trademarks function well there. What if it's artistic use? What if it's private use? If somebody wears a Sámi dress in a public event without any commercial intention, suddenly trademarks are very far away from that case. So what kind of things we want to prevent happening, and is it possible? So are they efficient? Accessibility is, of course, that just by registering some right, claiming a copyright, that's in the end of the day that doesn't protect you at all, but you must enforce your protection. You have to supervise the markets, contact the infringers, communicate, and in the end of the day, ultimately file a suit and protect your rights in the court. So it's a big process. Are there resources? Like Pia pointed out before, there should be a central body doing this or something. So are IP laws useful? If they are not accessible, then not. Usability, finally, the question that what would be the impact of using IP laws on certain TCEs? How would registering as a trademark a TCE, would it change the way people perceive it, it's used, what kind of social, political consequences there might be? It's something that should be very carefully assessed, that what kind of consequences, something is perceived as property, does it have influence to the very substance it is protecting? This is not, maybe yes, but how usable? Also the ownership structures in the traditional context are so much more nuanced and complex than maybe from the legal point of view. You should have one owner, he decides. But when we go to the communities levels, it's much more complex and how easily that can be translated there. So towards the answers and importance of the conclusions. So I underline this, that even if some answers would seem to be negative, IP laws cannot help us here, that result also is valuable because that adds to this analysis that what else would be needed, where are the gaps, what kind of tools should be needed to fill these gaps. So it's like both ways, I think. It's valuable. Practical actions, like already pointed out here, that maybe establish some kind of central body that will accumulate knowledge and take kind of be like a spearhead organization in dealing with these things, and also to communicate and educate the public. Legal tools and their possibilities are pretty clear. Law on paper, we can know what it is. Their practical usefulness is far from clear, but I hope today and these discussions can make some clearance for this question. Yes, thank you very much. Kiitos.
Kiitos, Tuomas. Thank you very much. Talmisle kokte kaittus sahkavuoro. Now we are having two speech through the connection. So first there is Jerker Rydén from the National Library of Sweden, and then Kim Pagels from the Ministry of Social Affairs and Labour. So please, first Jerker and then Kim.
Hello, and thank you for the invitation to speak. I'm very happy about that. The title of my brief speech is Improving Accessibility of Sámi Traditional Knowledge by a Copyright-Based Licensing Model, usually referred to as the acronym ECL. Next slide, please. Well, from my point of view, Sámi traditional knowledge does not recognize borders. That is my understanding. Hence, access to traditional knowledge requires cross-border solutions. And from the perspective of a cultural heritage institutions like mine, the Royal Library in Sweden, we understand that traditional knowledge is embedded in documents produced by, for example, publishers and broadcasters. But they're kept in not only libraries in Sweden, but also in Norway and Finland. And they are protected by copyright. The copyright, which is regulated in the EU directive from 2001 called the InfoSoc directive. And that directive exclusively harmonized in the EU and also EFTA countries as Norway, the exclusive right to copyright protected works. So to access these documents in a digital format, you require a license. Next slide, please. And as you probably understand, although you've never been, some of you, at a national library, we have many copyright protected works, millions if you consider audiovisual works, broadcast, etc. And what is required is what's called an extended collective license, usually referred to with this acronym ECL. Because you have so many copyright holders, so first of all, you easily conclude it requires a collective license to clear rights. You cannot do it one by one, rights holder by rights holder. And a collective license can be provided by a so-called collective management organization. But not all rights holders can be located or may have not even provided a mandate to a so-called CMOs. And the solution is then actually Nordic invention, actually Swedish one from 1950s, is that to have by law the collective license extended to the so-called non-mandated right holders, the ones who have not provided a mandate to the CMO to represent them and license. And this Nordic solution to mass licensing solves this copyright challenge of many, many millions of copyright protected works. Next slide, please. But how do you provide access to traditional knowledge embedded in these copyright protected works across the borders? Are there legal obstacles or solutions? Well, on a national level, extended collective licensing can be used. The question is then, can it be used across the borders? And the National Library of Sweden, which is the Royal Library is the name of the library, which it is a national library. We launched in cooperation with Åbo Academy a cross-border pilot in 2015. It continued into 2016, and it provided evidence that extended collective license can be used to give cross-border access to Swedish broadcasts, which are held in the collection of the National Library to researchers at Åbo Academy. And the conclusions you can draw from that practical pilot was that, well, if traditional knowledge would be embedded in these kind of documents, like in the Royal Library of Sweden, such traditional could be provided access to in Finland, Norway. And these, if you, from the other's perspective, similar documents in Norway could be provided access to in Sweden and Norway. So this is a solution, and the good thing is it does not require new legislation. It's non-normative. It's simply to apply existing legislation. It could be in some cases that you need to tweak national legislation. Now that's something that could be discovered and need to address on a national level. Next slide, please. So even as I said, it's been proven on a conceptual level that cross-border access to cultural heritage can be given using extended collective license. Many issues still need to be addressed, obviously, and this has been referred to before today, before my speech, I'm certain. You have obviously the Sámi perspective of traditional knowledge and how to approach that, and those are embedded in documents like newspapers, broadcasts, protected by copyright. But the first thing that you need to do to give access is to clear rights in copyright. And then obviously you have the question of Sami traditional knowledge and the Sami conventions, the IPA convention, etc. So there's still much work to be done, but the question, is this a solution or a realistic vision? I would say it is a realistic vision and it's doable. One possibility is to launch a study pilot to address these issues and to resolve them through collaboration between different stakeholders that need to be involved, and foremost, obviously, the Sami parliaments and other stakeholders which have an interest. And this is something I've elaborated on in an outline, which I referred to in a speech a year ago, also a virtual one. And I believe it's a good way. You sit down and it's very concrete, and the result would be very concrete actual access. I believe that is my last slide, if I'm not mistaken. Well, thank you very much for listening. I'm very happy to take questions, if that's possible. I don't know your schedule, but I think it's some minutes left. If not, I will again thank you very much for me and the opportunity to speak. And I wish you a very good conference.
Thank you for Jerker. And now, Kim Bagels.
My name is Kim Bagels. I work as a lawyer and manager for the Greenlandic government. From Greenland, we are eager to take part of this conference, although it's not possible to attend in person, as we see it as a new opportunity to exchange good ideas and procedures to protect our intellectual property rights. This is equally important, whether these rights are based on the traditional knowledge or traditional cultural expression or genetic resources from an indigenous local community as ours, or the more businesslike and commercial property rights as seen in trademarks, patents, designs, and other rights based on distinctiveness and novelty. We are on our way to seriously address the issue of TK and genetic resources in Greenland, but we have still a way to go. But we see it as an enormous opportunity to safeguard our culture and find new ways for our business ambitions. A few years ago, our local parliament, Inuit passed a law on genetic resources due to an upcoming local case. In short, Danish researchers had invented or were in the process of inventing a unique enzyme coming from chemicals isolated in so-called alkyd columns in a fjord in South Greenland. These underwater columns are made of a special type of chalk standing on the bottom of the sea, created by special environmental conditions from extinct volcanoes where rainwater runs through the cracks in the mountain and into the fjord. Due to the interest of these researchers to patent the ways to extract these chemicals from these columns and the methods to make enzymes usable in low energy detergents in, for example, clothes washing, the need for legislation was required. As inspired by similar Norwegian legislation, a law was passed and enacted by Inuit a few years ago. The law encompasses the rules and procedures on the rights of the Greenlandic government to collect and exploit its genetic resources, and to establish the conditions for this in accordance with international conventions and obligations. And this law equally applies to traditional knowledge connected to the genetic resources as owned by indigenous people and local communities. This means that exploitation in or outside Greenland can only take place with a special permission granted by the Greenlandic government, naalakkersuisut, including the receipt of economic or non-economic gain, and the agreement on sharing of such gains only be made with parties of countries that have signed the Nagoya Protocol. It has, however, come up that it's not always easy to make such an agreement, especially as to where and to whom in the process we should make such an agreement on benefit sharing. Should it be at the beginning, in the middle, or at the end consumers? Such an agreement should be based. Our business department is currently working this out with the researchers and license holders, hopefully with a successful outcome for both parties. For us here in Greenland, this is a very exciting pilot project, you could say, and I'm sure you will hear more about that in the future in respect of the inherent genetic resources to be found in our vast country. Now, in respect of the use of the ordinary and business-like intellectual property rights based on distinctiveness and novelty, we follow the Danish legislation on the subject, since the subject is still a common area of responsibility shared between the Danish and the Greenlandic government. Many Greenlandic companies, such as Great Greenland, Air Greenland, Royal Greenland, and so on, they have registered their trademarks and their patents and designs at the Danish Patent and Trademark Office, and also international bodies such as EPO, EU IPO, or WIPO, and often are the marks based on traditional knowledge. We had recently a case with the logo of the National Museum of Greenland, which is registered as a figurative trademark. It's an Inuit symbol called sun eye, which in the whole Inuit area is a symbol of life-giving and watchfulness, and often seen depicted in various utensils, for example, in sewing bags. The museum found accidentally out that the sun eye symbol was used by a minor company outside Greenland in their production of various tablecloths without any prior consent or agreement with the museum. As the museum was not interested in this kind of use of their logo or to make any commercial agreement on benefit sharing, our legal department contacted the company and asked them to cease using the logo. And the company immediately ceased to use the logo. Well, many normal day-to-day expressions and concepts such as anorak, kayak, etc. have roots in our area, although there has never been a real commercial interest in safeguarding such marks as intellectual property. But this is changing now. Also, we have tried to register traditional Greenlandic cultural expressions, such as the drum dance and mass dance on the UNESCO Cultural Heritage List. Whether to legally pursue this ambition probably depends on any concrete infringement cases coming up. Also, to answer the question, who owns the rights to such expressions is not clear. However, the most obvious would be Inatsisartut, our parliament. Another example is how to legally protect the traditional patterns and designs of the Greenlandic dress from commercial use outside Greenland without the consent and proper agreements. To my knowledge, there are not any ongoing cases, but they might arrive in the future. This is partly due to a stronger focus on intellectual property rights in the Nordic countries and in Europe as a whole, but also from our Western Inuit and native neighbors, where we have seen a stronger approach to have cultural mark registered on the basis of traditional knowledge. We find, for instance, the certification trademark IGLO tag for jewelry, knives, animal skins, and more, very widespread and registered for decades, also with governmental support in Canada. The same with another certification mark, the silver hand image, protected under Alaskan trademark statutes. This sign helps Alaska native arts to promote their works in the marketplace and enable consumers to identify and purchase authentic Alaska native arts. It's our hope also that the latest 2020 update of the Greenlandic Danish law on trademarks and designs will be a catalyst to promote and encourage the business community in Greenland to innovate and create new products based on both our cultural heritage and also ordinary commercial incentives. Especially the new type of trademarks will be of interest, especially collective marks and certification marks, protected declaration also of origin of agricultural products and foodstuffs. Moreover, the establishment of a counterfeit unit with the law update at the Danish Patent Office will also be an opportunity for us that we should use to safeguard both our traditional knowledge, cultural expressions, and the ordinary IPR owned by the businesses of Greenland against the infringements and commercial use without our consent. This required efforts from all sides, researchers, business, politics, but it's an important effort in the current world with fast globalization and worldwide internet and searching machines. I think the object must be to raise the awareness of traditional knowledge and IPR at international level, which is already going on at WIPO. I think from Greenland, we should push on from two platforms. The first being through our Nordic and Danish cooperation and to reach the European Union, who can then speak with one, but also with a powerful voice at WIPO. The second platform we can use, although probably less powerful, is through our NGO work in ICC, the Inuit Circumpolar Council, to reach WIPO and other relevant international fora to make sure traditional knowledge and traditional cultural expressions is connected to the ordinary world of intellectual property rights. Finally, like has also been done at the Sámi Parliament, the need to launch a project in Greenland to obtain a full overview of the IPR situation is important, both in terms of traditional knowledge and traditional cultural expressions and ordinary IPR in the business domain. Yes, thank you very much. This was from Greenland.
Kiitos Kim, thank you very much. Farkkanohka muu vuoro tämän konferenssa moderaattorin, mutta outaltaan haalian ietsän paares lyrihkapokte kiihti pohkahke hänkeri parka otna päi konferenssa fattaivuin ja min saami houtiin. Mun iskan valti raafalla tjahti tulkohki päässä. Talkkada liekkana olmos kalmosattan järalta vuulosin olmos arvujamu almo. Morea kere shikku ärrasa ere. Palti, shalti ja raika vel keres. Lihkus lean tan tade raavas muu vanahte in juurtosa tienalaatseko nuora asis takai. Mutta tuore kiihtosa ja täällä alkaa paneella saastallan mampouteen jotenkin Anne-Kirste Aikio ki maihtoi ma tämän konferenssin moderaattorin taas outoskuului. Kiihtumuu päällis savan hui mieläkittäväs ja takkar mouttii tahti konferenssana outoskuului torvolas roktomatki ja tolle oktavuodelle. Kiitos. Just shortly in English, my time for your moderator is now over. I thank every of you who are working hardly for the topics of this conference, and now I ask Anne-Kirsti Aiko come here to lead the panel and the conference since now. Thank you. Asis is out.
Hello for everybody from my side also. My name is Anne-Kirsti Aiko, and I hope you are fine and still awake. Asla Kuula did say goodbyes already, but we are still continuing. And we are going to have a panel discussion now, and it's interesting we have time to deepen in this question we have heard today, and also hear new point of views. The topic of the panel discussion is what experience with current IP systems there are so far, and what are the gaps as compared to previous solutions to implement the Nagoya Protocol and the UNESCO ICH Convention. We are going to hear before the panel discussion 2 introductory remarks. I think the Disney cooperation has been mentioned here today also, and no wonder as important it has been to Sami people. Now we are going to get a closer look what was made then. I would ask first Rune Fjellheim to come here as a role in expert in Walt Disney Animation Studios and the contract on Sami culture. Please, Rune, puhdas pohtiin. Haluatko lähteä vai?
Älkää kuvats slaidasko tiedättilämmästä. Ton Jaak. Joo, puoli holmut ja kiihtu poutiumi outs. Niin mä tässä tatjuvu jo. Tätä oftsparko Sámi ja Walt Disney Animation Studios lähe on naamohuvun jeskuude oktavuoden tai outti saahkavuoroin. Tällä järjeltä on ollut oodda mun puhtan täällä tämän ässäin, mutta mun kalkan vanhats per chelikit tei valtu raammai tässä. Oftsparko älki teinalaki lähin, että mi huomasimme, että Walt Disney Animation Studios löi Vietnamin saamis studiemätkis. Ja tämä oli kuitenkin tuohon kuhtnublois. Tätä lekkitin, kun maita ei tekään kaitiuvun, Shaajahan tuura tekään turista, tuura Sámi tikkis norkkapäälte ja leifina maita ei aanäris. Ja tätä lekke alle toudus ole, mutta mä lekkidoppi. Ja mi einusteimme, että sihkarit lähdään paremmin den Jovolan filmen, den Frozen koncepta oktavuus. Kuten hän mi puhkatiidi meille vedjan olu inspirationa norkkas. Ja det älge muhtun tjäps olemot samrädistalle barkas vaihkuit sametikki, että mian för att vara väldigt högt våra Disneyn. Just nu att det skulle väcka min samis inspiration. Mutta shodda. Disney vaikkua maana ei miehtä maailmi Israelslaakai. Så tällä huiteella että mi diehtit maja haiku ja läuveilös vaikka oftsparkat. Ja tielle ei valksatsi, kode häpmiuvui alkureive Disney, kos Sámi president, Sámi parlamentaaris räädibokti ja Sámi räädi oftas challe reive Disney ja lohkeat. Mi addiat tilehti teikka puhtan veg idea, puhta filmi ja orrude kun tilehti johtan Sámi asausemeltä ja viedään toppe tiedoi. No, hästi aikupet kievai elementtejä min kulttuurissa. Ja därför att skriva, det satt ju vid alla odeoimanus kuektua kaftsnublois. Ja doppe piti ju vu da vuodu kaipadussa. Doppe muistu heimme Disney, att just aikupet elementtejä min kulttuurissa vägt. Det färtpe muisti, att tähän on min opmoda. Ja det hiljataan diet, että automaatisesti tällaiset märksat diet vaadjudan kievait. Mutta mi hälit dialogadan ektui. Mi hälit niin hälistit ja kiehtsoli kauna joutusi. Voidaan tahkujuvu kohtulatjan oftsparku hämis. Ja kun saatsemme luopalat siirtei tällä muu kalkatahkujuvu. Ja mi tämä ei miestä jakpäällä olta luojimme fastadussa ja kun fastadus puolilla lohk joo mi aina hälitsimme din kuin hälistit. Ja mi hälit din täivät. Ja det Sámi parlamentaaris räädi ja Sámi räädi ger muus saat kodon joodi hittan parkku, kun hier hoktavuoda olmus Sámis. Saat kodon joodi hittan parkku, ja angal miedihin, mullekin tälle direktöörä Norkabel Sámitiks. Ja det mun lohken, että mi on fett hoks tässä tiima. Ja tämän valtuun siehtelän tiimas teillä puhut lahtu tämän tiimas tämän saalas. Tämän maasalohon kuottas siehtelän joukkuun. Täällä mun, täällä Pia Norkam, täällä Kristina Hätta ja täällä Jacob Adams. Min jäljis leimme tämän valtuun siehtelän tiimas. Ja täällä leimme maite vältän siisa olemui maite jeskude dikkin matteli räädadi johku mitida. Kuekte tuha no chakcha pälte kuda pohta. Mi kievahaimme muadde kolmamaanu tusse siehtai rammai mo täivadit. Ja det kievahaimme muantemaanu siehtäit iesaldstan tämän siehtädussa. Ja det käipideimme, että just Sámi almukaan kalka dinkuin rahkait suopamusa. Te färtle maittai almulas uossi tas. Taavalaisista stora fitnuda park tus chiikusis, tai on tusi chios siehtädussa. Te on ipias kassi jo aini tai tällä vuosin tämän parkuis. Mutta me adjuimme siinä farrui tienoa, että rahkaduvu maittai nu kohtuvu non-confidential version tämän sama siehtädussassa. Kun missä ei takaipäivys fas alemuga tämän alemua päälle saatte meidän vet tuosta chajit maimille suohpan. Stora kommersiella aktörer. Ja täällä suohpamus, mitä volle challiuvu tjaktjapälti kuektua oftsenbluis, maaddemaan ovtal tämän filma almuhuvui. Ja toppele Peter del Vecco, tällä valtuproducenta tämän Jigmon filmas. Ja täällä min kolma parlamentapresidentta Aili Keskitalu, Tiina Sanila Aikio, Perolov Nutti ja Sameradi presidentta Åsa Larsson Blindmala Challan Wallahi. Olles den processes mun namo in den volkesatji, että täällä min opmoda, tifettan kutniahtit. Täällä ei mai siva manne min tuolla heimilan positiona ja tjuautus ollestaan suohpamussi lei ko suopaimme, että Walt Disney Animation Studios itäpsan valti pääli läggo min opmoda voi i. Muuttu, ta färti kuitenkin tohki, että tämä ei min positiona, että min opmoda. Ja tässä vähkii ei sieltä olla mi oktavuudesta tienlaakka, että tämä rievtä i den dialoga. Ja dialog ei tjuautus tiesa. Tämä ei tarvitse vältti pieli, tiesta ei tarvitse lohk joo voi i, mutta tämä kuitenkin färtiäkki tohki, että tämä ei min positiona. Kun tämä oli siille rahkanan potentiella reaktioner i många just ei pastukieva huvun juoga min almuhatni ejamme opmodaka. Så anhats luohpas lessons learned Ostchettin min president la lohkan että min kulttuurilla elementillä min opmodaka ja tälle volksotsi kun mi kalksaastit teker ashipidra. Ja järät kuitenkin fett tohki, että täällä minua ainu. Ei tarvitse nödvändigtvis den tohki. Ja kun min oppoda, min hastalus lähte edja fett raka i njolkoluseessa. Ja ties mi läht otne. Moomi rahkai njolkodus oudskoului. Moomi naudi tjohk saami perustuumi tammuttu, että mi eedja tiehtit man pidällä saakka ja maaimi kalkseimme tohki ja äät. Ja storemushastelus täällä, että saami selvudas ikaunutta resursser tjohk ei ole mui kuhkiäikin prosesseja vuolta niin, että mi naudit häpmetien. Tiellä oktadei storemushastelussa. Att mi eedja odju äiki defineere maimi tuoda aivillit tenjan haltsämmen min opmolaan. Tiellä tuossa muu hastelustan paneeli. Mote. Kiitos.
Kiihtuu oluryne. Tähillä manka päivä tässä aiko mus jerrojuvui. Tahatte mo saami nakolekkeden ohtsparku sohpamusa tak Disney, mutta tällä ryne muisteli mot. Alki kiihtuu tas ja kiihtuu tämän hastelusasmanton bitch täällä paneelai. Tiet malle handelamus huipuerin outamerkan manka äärake ohtsparkui. Tän sullasas outsparkui. Muhto numohton tajahte, missä hän la olu kajalta vel chautkiahta mo midas outskuului. Savamis min paneella addadasa chautusit. Muhto misla maittai nuppi takkar alkosahkavuoru. Tän pohtaa tuolla Sameradi päällis Kristiina Hätta. Pursvahtin Kristiina.
Päivä. Good afternoon, or what is the time now? We've been sitting in this conference room all day, but having really interesting and exciting discussions. Thank you so much for that. As Anna-Kirsti says, my name is Kristiina Hätta. I'm the head of the cultural unit in the Sámi Council, where I have been working since 2017. Time flies when you have fun. The Sámi Council is a pan-Sámi collaborative institution, a member organization for Sámi political and cultural organizations in all of Sámi. And my background and education is from the Sámi art and culture field, where I have both my education, but where I also have worked all my adult working years. So I feel quite privileged to be able to do that and work for the good of the Sámi cultural field. On behalf of the Sámi Council, I would like to give a big thanks for the organizers for inviting us today. We are really happy to see the Nordic national authorities working together with the Sámi parliaments in this matter. This conference is a long-awaited starting point for an important Nordic collaboration to empower Sámi to protect our own cultural properties. And having a Nordic focus in this matter also shows a collective understanding and acknowledgement of the nature of the Sámi people as one nation across 4 national borders, which is an important understanding. As we have talked about today, this matter cannot be handled only on the one side of the border. It needs the competence of us all. Cultural appropriation, misuse, stealing, and copying of Sámi culture has been for decades and continues to be a severe challenge for the Sámi society. Since the establishment of the Sámi Council in 1956, we have been working with protection of our cultural properties on the agenda, and the cultural unit has been involved in several IP issues since then. We see some progress. For example, today we see a greater global recognition for indigenous cultural property. In the Nordics today, Sámi properties still, though, remain unprotected and at high risk for appropriation, as also Pia Njorkam mentioned earlier. Generally, this is because Western protection systems are built without our competence, our influence, and our decision-making. The consequence is that the structure isn't functional enough for us, and that IP tools, therefore, are little used in Sámi. At times, working from the Sámi perspective, protecting our cultural heritage is quite frustrating. Without proper protections that address Sámi needs and Sámi perspectives, these issues generally fall or are felt to fall upon the shoulders of each individual Sámi and also our already stressed organizations and institutions. This results also in a very ineffective, tiring working method where we often are unable to have a common approach, which would have enforced us. The Sámi Council, for example, receives weekly requests from around the world for the use of Sámi cultural elements, from major gaming companies, film production companies, literature, tourism companies, and many others. These requests are demanding because we lack a common strategy in Sámi today, a clear internal policy, and resources to meet the large and growing demand and interest. And I think Sámi Council is not the only organization, institution getting these weekly requests. We also see that some of our institutions are facilitating for ethical guidelines. But at the same time, we do not have ownership structures that can follow up guidelines, and their value is therefore in the danger of just becoming a paper. The Sámi Council see a need to coordinate and enforce Sámi efforts in this matter. There is a system of protection within the Sámi society, as also Pia Njorka mentioned earlier. The people living in our communities have learned the functions and the rules of this system, and the knowledge is passed through generations. The knowledge about how our culture can and cannot be used is passed on through teaching and practicing our culture, as also Petra Magga mentioned earlier, when practicing Duetji and learning from the older generations. In this system, all Samis has the ownership to our culture, inherited through generations, but also those generations' connections to land. We own our culture in many layers that communicate with each other. We own our culture as individuals, as a part of our families, as a part of our village, but also as a part of the bigger Sámi collective. Sámi Council often see that Sámi ownership and property is being challenged when people outside our culture wish to use it for commercial reasons. And we experience also that outsiders often don't understand and see culture as properties owned by the Sámi people, but only as something that is free to use however they want. Additionally, these uses do not benefit the Sámi society, not only because they lack the depth of understanding necessary to do things properly, but also because they do not recognize and respect Sámi ownership of our elements. So we experience two worlds colliding in this. A protection system for intangibles built without our perspectives, in miscommunication with our own existing Sámi legal system, which results in Western protections often going unused or misused to protect Sámi properties, and profound gaps in the Western system's application to support the Sámi people and our culture. This conflict can be seen in many relevant examples. The Beivash sun symbol example has been mentioned earlier today, proving to us that the Sámi system, the Beivash symbol case also proved for us that the Sámi system is still in practice, but also the lack of Sámi knowledge and recognition of Sámi properties in the IP systems. Or did we, in the Beivash sun symbol case, experience the lack of IP resources within the Sámi society, making it impossible for us to protect Sámi properties ourselves? I think we all agree by now, at least I hope we all agree, that to be able to protect Sámi cultural properties in a way that works best for the Sámi society, we need to resolve the relationship between Western methods and Sámi legal systems. And these efforts must be based within the Sámi perspectives and arise from the Sámi people and culture. But developing this important discussion is today challenged in the Sámi society by the lack of resources, and which of course also challenges our rights and needs for self-determination. Consistent and sufficient support and resources need to be directed to our efforts to enforce our own protection mechanisms and our own ability to continue the Pan-Sami cooperation in this matter. We need to decide ourselves on how to deal with and develop our cultural properties, and to be able to continue the most needed discussion within the Sami, both civil and political society, to empower political discussions that benefit the Sami society first and foremost. In order to be functional, we of course need meaningful involvement by the national IP offices, experts, and stakeholders within the process. It is within this system that we must work, of course, and where a Sami process will develop and a Sami mechanism shall function. For my final words, I want to share that we remain, and we have to remain, optimistic and hopeful for the future, protecting our cultural property, even though it's quite frustrating and tiring at times. It gives hope to be here today, to hear you all sharing our point of view that this situation for our cultural properties is serious and has been so for a long time already. And it's of course motivating to see that the Sami parliaments are prioritizing the work. There is a global and regional will for change. We see that not only in the feelings throughout the general society, for the new sensitivities of people, but also because we are all gathered here today, which is a great progress only years back. But there's still a lot to do, and we need to speed up our actions in order to develop. Sami civil and political society must be activated. And of course, Sami Council is ready to prioritize resources and support the coming process with any necessary means. Olo kiitos, and have a good panel discussion, everyone.
Kiitos, Christina. Thank you, Christina. And now I will ask our panelists to come here. First of all, we have representatives from Sami parliaments and Norway and Finland. Jon Peter Kintal, please welcome here. And Kalle Varis from Finnish Sami parliament. Kalle is online. Jon Peter, just take seat wherever you want. Then Aslak Holmberg is already coming. Welcome. Aslak is from Sami Council. Then we have Jostein Sandvik from Patentstyret. Please welcome and take a seat. And Tuomas Mattila from University of Helsinki. Please welcome you. Yes, and I'll just check if Kalle hears us. Kuuletko, Kalle, meitä?
Tänne kuuluu kyllä.
Hyvä, tervetuloa.
Kiitos.
We got already some questions from the introductory comments. We will be back to them later, but in the first, I would like you to raise up some points that's been heard today, or some points, or what you want to raise to our panel from earlier today. Jon Petter, would you like to start this important job? And welcome to our panel.
Sure, and thank you, Anne-Kirs. And thanks to the organizer for inviting me to be here today, and thanks for the lovely dinner we had last night. It's good to meet and greet again, finally. So that was a good evening. And today, I think we had a very interesting day. I think we hear that the Nordic Council of Ministers, they are interesting to have a meaningful dialogue with Sami people on the subject matter that we discussed today. And we also see the same approach from the intellectual property offices and experts. So from the Sami side, we see that we are willing and have already put a lot of efforts in trying to do a better job when it comes to maintain, protect, develop our traditional knowledge, traditional cultural expressions, and also cultural heritage. So I feel we can talk together, and I was happy to hear that the Nordic Council of Ministers has put sustainability first, and the same do we, and you have the 3 pillars of sustainability: economic sustainability, you have environmental sustainability, and the social dimension, and for us the culture. We want to be Sami also in the future. So that the Nordic minister focus on that means that they have the same goal as us. So I hope, like we heard from excellent presentations today, Pia, Christina, especially very to the point, what kind of needs do we have? And we just need some response from the states that we are living in. And we are very vulnerable people. We are relatively few and live in a huge area. And in many areas we are in extreme minority. So we need friends, we need help. So if we can build up stronger institutions to come up with a legal advisor on the subject in the 3 Sami parliaments, have strong Sami museums, other Sami institutions like Sami Allaskola, so we can point in the same direction all. And I'm very happy also that the Sami Council engage the civil society of the Sami people is important to bring on board. Thank you.
Thank you, Jon Petter. I think in the end of the panel we can talk a little bit about the future. Yes, and you said it's nice to see how much work and knowledge we have built about this question, but as Christina said, we need to speed up. What do you say about that?
Yeah, we like speed, so no problems. Well, of course, it's demanding, and you need more resources to work across borders. So it takes more time to have this consultations between the parliament and coordinate our positions. So it's not easy to do that in a rapid pace. And I see we struggle when we attend, much of my work is to cover traditional knowledge on the international level. And in many cases, we are not that well prepared because of the lack of time, and we have too much work to do in other fields. So this is only a little small part of my work. So I have to do a lot of other stuff. But maybe the experts share are in the office, they only work with intellectual property rights the whole day. But I have to do much more. So we have to come up at the same level in the parliaments on the issue. Thank you.
Thank you. I think we have to come back to the resource question later in the panel. But now I move to Jostein. Do you have any thoughts about today? What kind of thoughts do you have now? in the kind of end in this day?
Thank you very much. I have thoughts, yes. I started working in the Norwegian Industrial Property Office in 1994. I've been to Finnmark together with Steinar Pedersen, who many of you know, and I've been fishing and have also a lot of dodgy things that I have in my rucksack when going to fishing trips. For example, what I carry my coffee and salt in. From this, I started in the IP office, and year 2000, WIPO, the World Intellectual Property Organization, had this first start of the Intergovernmental Committee on Intellectual Property, Genetic Resources, Traditional Knowledge, and Traditional Cultural Expressions, or folklore, as it was called at the time. From Norway, we participated with delegates from a lot of ministries, and from time to other, we also had colleagues from the Sámi Parliament in the delegation. We were extremely active in the committee and put forward a proposal in 2006. We also held an international conference in Polhøgda, på Lysaker. But none of this was actually appreciated in the committee. The results were, well, maybe a bit disappointing. But anyway, now we are 15 years later. I think that even though we haven't seen any tangible results from the process, we have a lot more of experience. We have a higher attention to all these issues. And well, to be a bit frank, Finland was not very active in the first years, but we now see that we have Finland in the front, in the leading seat, driving these issues. And also from the Norwegian Sámi Parliament, we have now a lot of interest. And from the IP office, of course, we don't have much resources to travel, but we went to the Sámi Parliament autumn 2019 to talk about the Sámi sun symbol, and based on the discussions there, and also this request for administrative an administrative decision on the earlier registrations of the Sámi sun symbol, we had those considered invalid by the office. It's important to say that the discussions in the Sámi Parliament with now Silje, who's now president of the Norwegian Sámi Parliament, were not like we didn't proceed the case, but we gathered information from the Sámi in Norway. So I am heartened by the conference we have today, and also the achievements we can see among the Sámi people. But of course, from being a civil servant at the Norwegian Industrial Property Office, we don't have any specific agenda, but we would like to also contribute to raising awareness. And raising awareness is it's difficult, we know, also among businesses in Norway with regard to intellectual property in broad terms. And when our colleagues in the Sámi Parliament tried to raise awareness on the same issues, we know it's difficult. We know it's difficult for businesses to understand and know what is like a public good and what is your own as either a business or a community or even a people like the Sámi. So it's complex on many areas, and I guess we are all, to a certain extent, a bit confused, but maybe on a higher level. So thank you. That's my reflections today. Thank you.
Thank you. I think the knowledge and awareness has both built up in between Sámi people, but also in the ministry and the state level. So we are learning together, I think. Tuomas, what are your thoughts? We have heard that a lot of things has gone forwards, but what kind of impression you got from this day? What is the situation now for especially in point of view for Sámi culture?
Yes, thank you very much. And thank you for all the presentations we've heard today. It's been really fruitful and interesting day, and it's very nice to be here. One thing of this whole conference and the process behind it, I have to say that I think it's really a great thing, like Anna pointed out, that it's from the point of view that it's not negotiation, but like the Sámi desires first, Sámi internal dialogue first. That as a lawyer and from a legal viewpoint, it's often the marching order is that you define things from the perspective of law and how does this fit into the existing structures. But that's not maybe fruitful here, but it must be exactly this, that first what is needed, how things are conceptualized in this context, and only after then go to see like what the existing law says and what can be done. So this, I think, it makes sense. Secondly, I think this whole topic is gaining momentum internationally, also among the general public. More about these issues is being talked. It's not some niche particular topic like maybe 20 years ago, 30, 40 years ago. So maybe there is some kind of like, I don't know, snowball effect or something, but it's becoming more recognized that, hey, this is an issue, there are some lacks, something is needed to be done, which is obvious, of course. More the world is digitalized, more it's being like things go image first. This is more acute area. And if we think like in these days in the entertainment industry, in social media, everywhere is this kind of like a desire for authentic. And I think that's something where the value of traditions really arise, because traditions, if something, have value of authentic. So I would say that this question will be even more like pertinent or more like everywhere in the future, and so it's really important work. What else of today? I don't even remember what this question, but these are some impressions I've had. Tuomas asked, like you also pointed out before, that this conference would produce some concrete proposals, some concrete steps. It's often like very theoretical. I have some, I don't know if I continue now or something like, well, about my own presentation there, like I already went maybe one step ahead, because I think what is happening now, if I understand right, that now there is going dialogues, internal discussions among Sámi representatives, experts about these questions of what do we think of this all, what do we need, what do we want, how could it be done. And I think that's the important step. And like then kind of like a theoretical legal questions, how do we fit this in the existing structures? It is kind of like in the future, so these questions are just like there on the frame and can be answered. Some concrete proposals that already has been heard on the workshop level while preparing this conference, and I just say one if I have a couple of minutes. Like for example, what has been on my mind longer time is this, that to clarify more the kind of like IPR status of different traditional cultural expressions. Could they function as trademarks? Could they be copyrighted works? How are they like as legal objects? In Finland, we have the Copyright Council, which is like it's a body of experts who give statements on application of copyright law. You can ask anything about copyright. Them it's legally non-binding statements they give, but they have a lot of legal value. Sámi representatives could ask from Copyright Council an opinion of some TCEs, their status as copyrighted works. Are they copyrighted works? What this would mean is that even if the term of protection is expired, we would get some legal information that are they like original enough to be applied under the copyright law. And in Finland, in Nordic countries, we have this clause of protection of classic works, which applies even if the protection is expired. So the Copyright Council could make a statement that whether, for example, Sámi dress formally would fulfill the requirements of a copyrighted work, even if the copyright term is ceased, it would not be in force anymore. Still, this protection of classic works, which is a bit particular clause, but that could apply in some cases. If there's a blatant misuse of Sámi dress in some occasion, there might be something there. But there is no clear answers yet, because there's like you have to go on and examine, ask. It doesn't cost anything to ask an opinion, and to go different routes to find out. That was one concrete, like practical example of what could be done. But thank you.
Thank you. That was an interesting thought that we could check how it goes. Aslat, do you have anything on your mind? We have heard Christina's speech about this question in the point of view of Sámi Council, but what else do you have to add? What is your impression? What is the situation now? What are the main challenges now in these questions?
Yeah, so na parre päivi puhkaita falmuja pelis. So hello everyone from my behalf as well, and thank you for good discussions. So my reflections from today are that we are essentially talking about self-determination here, and that is an inherent right. So it's not something that can be granted to somebody or taken away, but we are mainly talking about to what extent it is respected or violated. So those are my two takes from today's discussions. We have heard of cases of violations, but we have heard cases of which could work as good practices. And another thing I've heard a lot is the call for a need to build our own structures to deal with these issues. So, and of course we've heard about the important work that is done under WIPO, and indeed it's important to develop this kind of global guidance or rules on how to deal with these issues, but we've also heard that it takes a long time to do that, and it's a very slow process, so we cannot just wait for that to happen, but we can find our solutions case by case. So if we are to try to see perhaps build this kind of a bottom-up approach to look at what kind of violations have there been. Okay, let's ask, can the Danish jewelry company B. Christensen own the name Sámi or Samer and sell essentially our traditional tuetti under that name and trademark? Well, no, it cannot. So how do we solve that? Another example, can the Finnish copyright organization Teosto, or is it the rightful owner of traditional luehti, Sámi traditional music? Well, no, it is not, and it cannot be that they receive money from traditional luehti and there isn't anything coming back from that to the Sámi. But we've also heard of good practices, and as we are lacking these formal structures on how to deal with it, then we have to take this ad hoc approach and see it case by case. And I think this Disney example is a perfect example on how can you establish a good cooperation, and it is a major step for the Sámi to assert our rights, because it is not that people would come approach us and we know this is kind of Sámi, so ask permission, but that the Sámi were approaching them, asserting our rights, saying that this is our property and you'll have to accept that. And then from there on to develop a way forward. And as we don't have that structure ready, then it has to be done case by case. And that was one good example on how it was done, that there were the 3 Sámi parliaments and the Sámi Council, which established a group to work on that matter. So if we are to upscale that or formalize it, then that is what we need, to have something that would be meant to deal with these kinds of issues, so that we wouldn't have to do it case by case. And it's not like we don't have any structures, but they are not very firm or strong enough in capacity and resources. Like we have the Sámi Parliamentarian Council, which could be strengthened to deal with these kinds of issues. There is the Sámi Symbol Committee, which doesn't have a secretariat, and its work is quite slow for that reason. So this is where I see the way that we can work together, that we cannot expect state structures to solve these issues, but we can work together to build up our own capacity and structures on how to deal with these issues regularly. So I think I'll stop there for now.
Thank you, Asla, for also looking in the future, what we could do then. But when we are in this situation, what we are now, so I was hoping that Jon Petter and Kalle, also from Finnish Sámi Parliament, would give us some examples of maybe good practices, what kind of experience you had, maybe gaps or bad experience also. But now I give Kalle also possibility to reflect today's speeches, and also Kalle, please, if you also continue with your thoughts about the work now, and do Sámi parliaments have very good experience with the current IP systems? And I know, Kalle, you have especially been working with the Nagano protocol, so if you want to share us shortly that. But Kalle, please.
Good afternoon, everyone. On my behalf also, it's quite late already in the afternoon, so I will be very short. Thank you for everyone for today's good speeches. This what we have heard today has strengthened my point of view, the big picture in my head of what is going on in this IP rights system. There is some work going on many directions, but the work is still incomplete. We have a lot of work to be done everywhere almost. That's what I think about this topic in generally. We already heard some thoughts about our good example, the Disney case. So I won't talk about that. We were somewhat along in decision-making process in that in the same case, but I will have some words about Nagoyan protocol and our law on implementation of that genetic resource thing in Finland. This is some example which I would not describe as a good one. On the opposite, I would say that we must learn something from this example. It's the main message about the Nagoyan Protocol and implementing the protocol into Finnish legislation. We have had this law already since year 2016 in Finland. And the main points in that law are that it should regulate the usage of genetic resources which have some relation to traditional knowledge of the Sámi. It should make the framework for fair benefit sharing, which is a good thing, of course. There is good intentions on this procedure, but still in the end, we don't have anything to share, at least by now. Also, it should create the accessibility to these genetic resources under certain conditions, which should be negotiated between the user part and Sámi Parliament, but also with the state part. This benefit sharing especially has been thought to be made through these negotiations between these three parties and these conditions about under which this traditional knowledge can be used by a third part must be accepted also by state party, which is very negative thing in this law, because, in my opinion, it violates the Sámi people's right to self-determination and ownership of the intangible cultural heritage and the traditional knowledge. It's the worst point in this law, in my opinion, and it's a bad example of how these rights have been implemented in the legislation of Finland. And then some more practical points on this process. The law has been established and it has been on force since the fall 2016, but now this year, 2021, our Ministry of Environment started a project which is thought to establish a way how to implement the practical solutions for these processes. And it's 5 years later. It's quite a long time, but it's better than never, I would say. There are big problems in this process because, on the other hand, we don't have this database, which is meant to be the whole basis of the system under the law. And on the other hand, we don't even have the practical system on how a third party could use the information which theoretically should be put into this database. So we have the law, but we don't have anything under the law, which is a big problem, and we criticize this way of implementing the law already before the law was even made. But the state of Finland did not want to hear us because they were busy about this law process when the Nagoyan Protocol was already accepted, and the state of Finland had to implement the law very soon in the national legislation. That's the history shortly about this, but I think that when this process is to be taken seriously after 5 years of implementation of the law, it's too long time, and if we see what we have to be done in the future, I still see at least many years work before this system is actually made to be done, made to be finished, so that it could be worked as a practical solution for this problem. So my reflections are on this point of view quite the same than most of the speakers today, that we have somewhere somewhat good intentions, but that's actually what we have. Some good examples maybe, but what we are missing at the moment, I think it's the political intention to make these things really come true. That is what I think we need, at least in Finland today. And of course, if we think about cooperation between the Sámi Parliament and the Finnish state, it has been done by now in a good, how could I say it, with good thoughts between the ministry officers and Sámi Parliament, but by now there has not been actual resources for establishing the real practical system and the process to make these things really come through. So also the resource thing is a big problem here in these topics. But I'm hopeful at the moment, because we have this project now going on. Maybe we get good results and good practical solutions through that. That's at least what I hope. But that's actually all I can tell you at the moment of this process. But maybe I could throw the word and give a question to all the experts here for the future investigations and research of what are the things, the main points and the main risks, what we should take into account in this work, what we are doing now to make this law of the genetic resource protecting and traditional knowledge to come true. About this.
You finished, Kalle?
Yes, I could.
Yeah.
I could stop here, and maybe if someone wants to ask something about this process, I'm happy to answer. But on my behalf,
I will give
thank you.
Word later.
Conference.
So, yeah, Jon Peter, I have been asking you to share us some good practices, maybe what you have experienced, and also if you would like to also add what Kalle was telling about the work between Sámi parliaments and the ministries of the state. So if you want to comment that also, so it would be interesting to hear more about that.
Yeah, that's also my. Thank you. My good example, and I shared that information with the Sámi Parliament in Finland last week, and we will have like phone calls between us and I will try to help and inform them as best as I can, because in Norway we had like a consultation on the Nature Management Act. Was a new one who came in 2009. And then Norway ratified the Nagoya Protocol, and then they had like further regulation that was attached to the Nature Management Act, and that regulate Sámi traditional knowledge associated with genetic resources. So the scope is of course limited, so we have no practical examples so far. But who knows in the future what will come. But to explain it, the law is like this when, like, let us say, a pharmaceutical company are thinking to invent something with the use of Sami traditional knowledge and biological diversity, then they have to contact the national focal point in Norway, and we have an agreement with them that they contact the Sami parliament, and then we discuss like a process for to come up with like free, private, informed consent for the group that is the right holder of that knowledge. And if it's totally collective for the Sami people as whole, then of course we have to alarm the Sami Parliamentarian Council. But it can also be not that huge. It can be a smaller group, a group of families, who knows, can be a Sea Sami fishing community, reindeer herders. So we have to do that process. And during that process, we also will discuss like how to come up with benefit sharing, to have like negotiations on that. So then the regulation require informed consent from the Sami right holders. So we will wait and see if we come up with a practical example, but in a theoretical way, it's going to work, in my opinion. Thank you.
Yes, the beneficial sharing has been mentioned a couple of times, and we of course know that it has to be money. It can be other things also, but we have also talked about this lack of resources. So, what, in your point of view, could that beneficial sharing be one solution to our resource problem?
I'm not sure about that, but that can be one. Of course, if you have a big case where it's a lot of benefits involved, that will, of course, can be a part there. But in the regulation, it also say like we have like a non-monetary benefits. So that can be like building up stronger Sami institutions. Whatever we desire to have. And I think this regulation goes straight to what Rune said about their work with Disney. So it's a kind of same process we can set up. So it's up to us to decide what kind of benefits we need from that and that case. Thanks.
Yes, but you underline the FPIC principle in these processes. I want to continue this resource question with Jostein and Tuomas. It's not only your responsibility, but you have heard that Sami institutions say that they have lack of resources to work with this question. How do you see how could we solve this question, and whose responsibility is to help Samis with this question? And yes, so I would like to hear your thoughts. Do you want to, Tuomas, start?
Yes, thank you. It's indeed one challenge of this issue that we're talking about private rights here. So you have to be active yourself to enforce your rights. And because if it would be some public law, let's by an example, think there's the law on Finnish flag, for example, or state emblems, or these kind of public laws that regulate if you want to use flag, you can do it, but you have to follow certain protocol or certain rules of respect. And these kind of like public laws that the public authorities would take care, that could be some solution to some cultural elements as well to go that way. That doesn't address the ownership, and I don't think that's what I've understood from the discussion, that's the desired way to go. But when we go to the property point of view, then it is your property and you have to be the active to take care of your property. And then it's the practical question, the resources. And I think it is fair argument to say also that for historical reasons, also resources are lacking. It might be also that during the decades, there hasn't been some same kind of like, let's say, revenue accumulation of using cultural resources that maybe have been in entertainment industry or some other like, let's say, traditional IPR fields. So there is kind of like argument made to be done that the indigenous community should have a support to enforce their private rights, because also there's kind of like a lacking some historical accumulation for that. How it's done, I don't have an answer either here, how it can be practically done, but of course in principle, by using your rights, you should be able to accumulate revenues that you can then again use more to incentivize your resources and produce more. It would also like, this is a good question, that if cultural expressions would be protected more strongly, would that incentivize communities to more actively put them out? Because if we think like the logic of IP laws, let's say copyright laws, is that you get the protection, but the point of giving you the protection is that you go to take your work out and try to distribute among the public and to make works accessible. So I think one problem is that, okay, traditional cultural expressions, they're lacking the protection. It's like difficult to kind of like share them with others because you don't know what others are going to do with it. So in that sense, there should be resources to enforce the rights, and that would help probably also the other, like the public in large. And yeah.
Justin, you talked about raising the awareness. So what else, how do you see your role, or have you any solutions to this, this question?
Thank you for asking. But I think we, like when we visited the Sámi Parliament in Karasjok in autumn 2019, that was based on a request from the council, and again, just to get in touch, that's a start, and I think that we have to work that way, and that could be coming from us as well, that we could ask to contribute or something like that, and probably we go from there. And if we get instructions from like the Ministry of Trade and Industry, I guess that they would find that we should set aside some resources. They could do that way, but I think more of like an actual request from the Sámi Parliament to us could maybe be one way forward, and we would certainly look into that and try to respond in a proper way. So, well, I guess that's it.
Now I move a little bit to another topic. Christina was telling that the questions about the use of Sámi culture in different kind of projects, they are coming weekly. I think a lot of Sámis know that the phone calls and mails are coming. And now I have a question to Aslan, and others can also add. Yeah, we know that questions are coming. Rune was saying that we need to build up some kind of way to solve these questions. What do you think, Asla? What should we answer now to the people who ask from us? What can they do, and what is the solution in the future? You said we have to build up these systems we already have. But what we do now, actually now when the questions are coming all the time?
Yeah, well, in the current situation, I think these questions are dealt with in some way, and as I was referring before, that there isn't a systematic way of dealing with them, but they are dealt case by case. And yeah, I know a lot of Sámi institutions, even individuals, get many requests to evaluate certain projects, or at least on some informal level grant permission on doing of giving a consent in a way. So to some extent these requests are dealt with whatever the way would be if the Sámi parliament gets questions, and in accordance to their capacity they will deal with it. But yeah, I think the story that perhaps everybody has already gotten tired of hearing today is the capacity issue and the need for building structures. So one example is research and indigenous knowledge. So there isn't a way of dealing with that now. I mean, I can sense that there is a growing respect for indigenous knowledge and for our rights in regards to that knowledge. So that means that there is an increasing flow of requests coming to different Sámi institutions on that matter. But for example, if somebody wants to do research on Sámi indigenous knowledge on Teatno and salmon, then there just simply isn't a body that is capable of giving that right. So if we go back to the Nagoya Protocol and how there is a requirement to fulfill the free, prior and informed consent and establish mutually agreed terms, but with whom? So it is just where we are now, that this part hasn't moved on, and it is also on the larger scale. Like if we are dealing with some collective Sámi, maybe symbols, then there isn't a formalized way of dealing with that, but that also reflects back to the community level. Like there needs to be a way of addressing these requests and providing support to communities to be able to address these questions with the capacity that they know what are their rights and so on. So yeah, I guess that's as clear of an answer as I can give.
Yes, we know that the question is quite wide and it has a lot of different it's a question in filmmaking, in research, in different kind of fields. The questions are coming all the time. Jon Petter, is this question and responsibility for Sámis now to solve this? And what are the Sámi parliaments doing with this question right now? And Kalle can also continue afterwards.
Yeah, thank you. I don't have a clear answer on that, but as we heard earlier today, some people talked about step by step. Maybe that's a smart way to go forward, so you can build up the needs from our sides, and the competence and the capacity after a while. But I think we are now aware of the difficult situation we can be put in, and we are capable to respond to issues. But it's very frustrating to work in that case by case situation. So I hope for a better future on that, and I think we have the system in place. We just need the resources and the people. Thank you.
Thank you. Kalle, do you want to add in this, what is the point of view of Sámi Parliament in Finland? Do we have the instrument or already, and who are we sending these requests to? Do we need some kind of new group who can answer this and handle this, or what do you think, Kalle, about this question?
Thank you, Anna-Kirsta. What comes to the Sami traditional knowledge, which has the relation to genetic resources. It's named in the law that the partner for the negotiation is Sami Parliament in Finland, but it's only for the content which is included in that law, which has some relation to genetic resources. But for the rest of the IP rights, there are different connections to different authorities and different systems. So I also do not have a clear answer of what kind of body or what kind of process we need to name all the partners for all different types of cases what we could have in the future. It's very complicated system because there are many laws and many systems talking to each other in these issues. What we could use, like we have heard today, there is some good points in the system what we have in the Nagoyan Protocol at the moment, but also bad points, because good point is that there is this principle written in the law that this benefit sharing should actually happen, so that this knowledge could be used by a third party. It's a good thing what we have in the law at the moment. But on the other hand, the bad point is that it's not established in the law that this actually should happen through the free, prior, and informed consent of the Sámi Parliament. If you see what the law actually says about it, it is that Sámi Parliament negotiates with the authority, and authority accepts the conditions under which this knowledge is to be used by a third party. So what we have in the law is not the best solution, and I would not be very happy with that. We need something else too, so we have a lot of work to be done with these things in the future, I would say. Thanks.
Thank you. Thomas.
Just a small comment to contribute what has just was said, because also the important point of view here that if there be certain Sami institution or body who would in centralized manner represent and educate and negotiate public, it's an important point of view that I think that would protect also the interest of kind of external users or those who would like to use or somehow use Sami cultural expressions. Because what I mean is that for example, many companies, artists, they have a goodwill and they want to respect and ask for a consent to use. Oh, I don't know many, but at least some do. I don't know what's the overall perception. And when there's a company, I don't know, travel operator or someone who would like to be, let's say, respectful, who they can ask this consent, who they contact, like you said, that it's very like a ad hoc, very piecemeal approach now, contacts here, there. But if we think of like a, let's say, business practitioner, it's a risk for them if they don't know, they want to act in prudent and respectful way, they don't know if they have done it correctly. It's a risk that what if later on they make, I don't know, they make a film, they make music, something, later on they know, you asked, you didn't have real consent or real approval or something, so it's a risk. So I just mean that from this point of view, it would also be in the interest of non-Sami operators to have, that Sami would have resources to have this kind of centralized body who could negotiate, communicate, the rules would be fair, and who desires to use Sami culture could rely, okay, with them I can talk. These are the conditions, and in that sense, there is a strong argument also that this kind of like Sami body could be funded by, I know, copyright associations who accumulate fees or some kind. It's not only like only private interest in there, but I think it's also in the interest of functioning of creative industries, functioning of the markets that this could work.
Yes, while the awareness has raised, so also the questions have raised, so that has made the pressure for the Sami institutions to answer the questions. But I think someone mentioned this different kind of protocols we have. So that's one kind of solution to that we can say that we have some kind of protocol to, for example, tourism, ethical tourism, and then we have guidelines for that, but also, was it Christina who says is nobody like watching and how the protocols are fulfilled really? Yes, I think we are soon going to the last question, but I had a question to Tuomas also, because you said that there are you brought this in your speech, this question, is there anything we can done with current IP laws? And you brought us a lot of questions. I was thinking while listening, what do you see is the most important for Samis of those questions right now? Where should we start? You know, we don't have so much resources, so we have to start somewhere. So what is your advance? Where should we start in your questions, what you brought in your speech?
Well, I think one important field would be that to locate, well, if we think like really like a lawyerish approach, the problems first. It's like you go to a doctor and doctor asks, okay, where you hurts? I don't know, my throat is sore or something, and they give you medication. In the same way, kind of like I see, like where are the problems right now? I mean, the most urgent problem, where there are external users who don't have goodwill, who really like say that I don't care your rights. See what is there, and then can these cases be somehow countered with IP rights? Like if it's commercial use, then maybe there is something that can be done. If it's private use, it's very difficult. So go very like do problems first assessment, that what are we wanting to counteract, and then make legal analysis based on that. That would be like one very practical thing that could be done. And just I don't know, another thing we hear this kind of like negative examples, the sound symbol registration. You mentioned us like the Samer trademark, which is just very weird thing in Denmark. The Sámi people registered as a trademark. What if these registrations would have done by Sámi Parliament on the behalf of Sámi? I mean, that would be like protection per se, IP-wise, to protect these in order to stop the abusive use of these symbols. So there are I don't know if I would propose to do that kind of thing, because also there is it's not only legal assessment, like I said, there is also social, political consequences that should be elaborated. Okay, what happens if we actively now take these IP rights and start? But it's possible. I mean, there are possibilities there.
Thank you. Kalle has asked for a word. Please, Kalle.
Thank you, Anna Kirste. I just thought to reflect very shortly what Tuomas and especially Tuomas just said about this point of view of the third parties. Yes, I think the same, that it's at the moment very complicated for all the parties that we don't have clear bodies to give answers or consents about usage of something which has relation to the Sami culture, for example. It makes the thing for everyone very difficult, and I would say that even for those companies, for example, who actually want to do the right thing, it has been made very difficult for them, and therefore there is the urgent need also for political decision making about this topic, at least in the sense of who actually can give the consent. The Sami Parliament, of course, is the official representative for the Sami people in generally. But as we just heard, for example, this dead fishery case or these topics around it are something that it's very unclear if the Sámi parliament actually could give this kind of consent. So it shows that this issue is very complicated, and there are many things to be taken into account when we make this kind of system of a body or bodies who can give this kind of consents. We have thought this on our work in the Sámi parliament, but we don't have a clear answer to that also. But it was a good notice that this is one of the main fundamental questions that we have to answer in the future and think about the different possibilities. Thanks.
Thank you, Kalle. And now I ask you to a little bit think about the future and what should be done in the future, especially in Nordic countries, but of course in international level also, if you wish to point something out from there. So my question to you all is now, what is your expectation? What should be done in the future, or what are the next steps to get further in this question? Is there someone who wants to start with this question? Jostein, you can start. What should be done next?
I think Ole Henrik Magga inspired us when we started working with the word recognition and respect. Of course, those two important values should be carried on into the future. And I guess that the Sámis just have to develop those values further. It's hard work, we all know that. But I guess that is how it is. It's not different, say like universities working on commercializing science. They have tech transfer offices set up. These are also bureaucratic institutions, and they suffer from criticism because they are not effective enough. So if the Sámis set up such tech transfer offices or consent offices, or I don't know, you will have another bureaucratic layer. Of course, that could be helpful, but what is the perfect solution? It's difficult to picture, I guess. But you have some very good examples from recent years that you can probably learn from. And I guess that is all that I can say. Thank you.
Thank you. Jon Peter, do you want to continue? A lot of work to Sámis, but do you have expectations to states or the ministers in this question?
Thank you. I can start with saying what we not should do. That's spinning wheels in Geneva in the intergovernmental panel or in the intergovernmental committee, because as far as we can read, nothing much is happening there. So it's a very divided committee. So maybe we can ask Finland or those states who cover Nordic states that cover IGC to alarm us when there is a positive movement in the committee, because it's extremely expensive to travel to Geneva and live there. So I think that's for the moment a waste of resources for us. We can spend those resources in a much smarter way. And I think the follow-up of the INCAS project, as we heard today, is a very good way forward. And worked together, the 3 Sámi parliaments, include the Sámi Council as they have worked together and put our efforts to seek for funding, for resources, for increased capacity. That will be a good thing. Thank you.
Thank you. Aslat, you said we should build up our own systems. How we do that, or do you have other thoughts what should be done in the future?
Well, I think one thing to do is to highlight those good solutions that we have had and point out that we can offer authenticity. Take it Sámi Tuetji mark. That's a good example of how we can provide a guarantee of authenticity to people, because there is a demand for that. So one thing is to highlight that, and at the same time you can see what is not authentic, right? The other good example that has been mentioned a few times here today is the Disney case. So we can highlight these ways that you can work in an ethical way, but then again that brings us to the question of how do you do that? And yeah, going back to this capacity question, as a former member of the Sámi Parliamentarian Council, I can say that without a secretariat or somebody working for it, it doesn't fully function. Like when I was sitting there, I believe it was the youth secretary who was trying to coordinate the Pan-Sami self-governance in addition to all her other work. So you can see the discrepancy there, that it's not the formula that really works. And that's not critique to the Sámi parliament, but it's just a matter of resources on how do you make that work. And in this field of intangible cultural heritage, I see that symbol committee as a way forward to build up on that and try to establish permanency to that and build up that capacity.
If I give word to Kalle and after that to Tuomas. Kalle, what kind of expectations do you have in the future? Are you there, Kalle, still?
Sorry, I had to take the mute off. Yes, I'm here. My expectations for the future are especially that the necessary resources will be pointed out from the government of Finland to this work, so that we can really implement the legislation what we have, so that it could really work. That's the first step. But the next step is of course that if we find, and when we find good fundamental solutions to these big questions what we have talked today, we also need resources to start working so that these problematics could be solved in wider sense in the future. But there is a big need also for the experts to work with these questions, to find good solutions to these questions which are not fully answered according to the information what we have now. And there are a lot of expectations for the work also on the Sámi Parliament side. We need some further decision making and work also here about these questions, how the Sámi community wants to handle and solve these questions in the future. Thanks.
Thank you, and Tuomas, you will have the honor to end this panel with your last words. So yes, but please share us your thoughts about.
All the time that's left is mine.
Yes.
Thank you. Well, I'll be brief. One thing I guess would be important is that, of course, like a cooperation Nordic level in all aspects, like For example, between patent offices, I'm thinking this sun symbol case in Norway, I don't know, it might have some precedential value also in the use of other patent offices between the drafting of guidelines in the patent offices. How do we receive these kind of applications that might contain some important cultural expressions? So obviously, I mean, at least that not in all Nordic countries, patent offices proceed with their own guidelines, or there's big differences. So that's one point of possible cooperation, I'd assume. Secondly, of course, what is already happening is just great that there's like between Nordic countries, all the Sami communities together have formulated, like in this IMCA study, the joint view. How do we see these things? And I would I hope soon in the future this is articulated to the wider audience. It receives attention in the media. It is like publicly known that this is what how Sami people perceive this issue. This is our property. It's our culture. You have to ask our consent. Put the law aside. This is how we view it. And then anybody who wants to respect and act in a goodwill, which I believe there are still quite many. We see how people have been very sensitive about this cultural appropriation claim, which is of course sad that people don't buy Duoji handicrafts because they're afraid of cultural appropriation. But what's positive is there that it shows that people really care. They mind about this thing. They are. So this Sami view, when it's that everybody will know that, okay, this is how Sami people view these things, it would, I think, soothe many things. Because there might be also, let's say, innocent infringement or something that some business operator, it really doesn't come up that, hey, it might not be just some old symbol you're using. This really matters to somebody, you know, that these kind of cases. So more visibility, more recognition, I think that might open up many Southern roads. And then, of course, in the end of the day, there is some, unpleasant cases that there is some who really doesn't care and wants to exploit. And that's kind of like where you then go to the IP fighting and really like in the hard measures. But I think there's a lot to do before that. And progress is very positive and hope also a speedy one. Thank you.
Thank you. And now we end this panel to these words. Thank you all for participating and thank you for listening. And next in our program, we have a break until 5:30. And after that, we have a short slot with Q&A. You have possibility to ask questions from today's speakers. So we have a short moment for that. And after that, we will probably hear about the plans for the future, hopefully. But yes, now we have about a 40 minutes break. No, jos mi vasto jatkit. Ja päässä lohpakuului, muhtomihan lähäljan falla taasa lohpivel veijolasvuoda järrat. Ona päivä huumikon ja maittai panelistaikon le lohpijärrat. Tai muutui buktit kommentai vel taasa lohpino. Että tällä tasa veijolasvuotta. Mutta adjubet tällä jutsi, lääkodis kajalta kahja mun muistelan tampotta ahte tappela takkar listu, mi bits taitte taas johtit ja tahla tekkar mi järra ahte adjuko tiin oktavuota tiedui johki tämän jouhkui ja tahvaivilta tämän e-mail oktavuota tieduit. No takkar kajalta pohta pahpiris ja merkebet hietsnama pohta just la ornikis. Tällä vel nubbi papir ja taht järra koven lobby. Nuotte tappella kovjuun ikte ja ne nuotte taht addatasta lobby keavahit tai kovait. Lähkota tieppeta pahpira täällä. Onko Anna-ne? Puerre, tällä tieppe joutus. Nuotte chalisteet tiehko. Puerre, mutta tällä veilasvuotta järrät ona päivä sähkövuorotollikon tai panelistaikon just tappeleat täällä sähkövuorot. Puerre, Tuomi Saslat.
Thank you. I was wondering if Matthias Oren is in the internet world, whether he could share some of his reflections based on today's discussions and what kind of thoughts or concerns he have and would have from the discussion today, or positive feedback.
Yes, I'm here. Can you hear me?
Yes. Yes.
Okay. That question came a little bit unprepared, but I think from what I can hear and also from my previous experience within this field, I think the challenges are basically fall within two areas. The first is, which I think the discussions are focused most on, are practical. I mean, how do you resource the relevant Sámi institutions, the Sámi parliaments and so on, perhaps the new bodies established for the purpose of better protecting the Sámi culture heritage? How do you resource it? How do you get it to work in practice? That's not really my field, but I can certainly see a challenge there, and I hope somehow that can be taken care of, so that, because it is obviously an important work to be done. And I think that the point made by a few also in the previous panel that, I mean, I think if the Sámi are really in trouble if we cannot even take care of those that want to do good, those that want to do right. And I agree with those that made that observation. I think that many are like that. They don't really want to offend the Sámi or misuse the cultural heritage of the Sámi. They want to do the right thing. But that is, of course, very difficult if there is no one there to advise them or give them the answer what to do there. Can you do that? Can you not do that? And so on. So I think this has to be taken care of as soon as possible. And I hope that can be done. But again, that's not really my area of work or expertise. The other one is more legal, the area where I am. And I think what is really needed there, there was the proposal made that you can engage this, I can't remember the name of the body, but this Finnish institution that can give some pre-advice or kind of pre-decision whether certain Jews would offend or break Sámi rights or cultural heritage, or at least in an IP perspective or from an IP point of view. And I think that could be good, but I think that such a body would also lack the capacity to kind of translate conventional intellectual property rights to the area of traditional knowledge, traditional cultural expressions, and so on. I think there is a lot of work to be done, kind of, and that's of course what they try to do in this WIPO IGC, which I participated in for many years in its first area of work, the first period of work, the first years. I haven't been there for a long time since then. But that's what they, at least one thing they tried to do was kind of translate the conventional intellectual property rights into a more, how they can be better accommodated to protect the more collective and so on work of indigenous peoples, including the Sámi. But there's still a lot of work to be done there, and also in a Nordic context. So I think there is also something to get a clear understanding, how does the law that we have actually apply to traditional knowledge, traditional cultural expressions, and other parts of the Sámi culture heritage of the intangible sort. So I think that those are, broadly speaking, the two challenges I see. One practical and more on well, the second is practical too, but it addresses more specifically the legal challenges. Thank you.
Thank you, Matthias. Is there any other questions? Yes, there. Just wait a second to get the microphone.
Okay. Hello, my name is Virpi Jääsk, and I had to write my question down because I'm going to get so nervous saying all this. So, my name is Virpi Jääsk, and I work as a project manager in Sámi Education Institute here in Inari. And in my current project, we try and find mutual opportunities for local craftspeople and tourism, business opportunities. And so here I represent those parties, as well as our school and Inari and Utsjoki municipalities. What we now know is that there is interest and there is money to be made in crafts within tourism. There could be money to be made, and that would benefit not only tourism, but craftspeople, both Sámi and non-Sámi. And we also know that Tuoji is in crisis. People get old, and the livelihood has not been very appealing to younger people for many years now. And also we know that the public, the tourists, ask if they can buy this or use this, if it is cultural appropriation or not. They hesitate buying things from here. So, how, in this situation, how can we promote business in this uncertain situation? And my question is, how can we do that, and who can we ask for consent? Now, because we cannot wait for many years for the answers. Who can we ask? How can we know if our products made of local materials, maybe Sámi traditional handicraft, maybe modified, maybe new design, made by our Sámi and non-Sámi craftspeople? Who can we ask that? As much as I want to give the time for the thorough internal discussion, I think we do need answers right now. And I have another question too, and I'm asking it this time for myself. I am also a craftsperson. I am a master of shoemaking, and I am a Inari Sámi descendant, but I'm not registered as Sámi. But I have 4 Sámi children. I have worked in reindeer herding, I have learned the skills to make materials myself, and I have made materials and products for 3 decades. Can I sell Sámi traditional handicrafts? Can I make money of that? Who can I ask? And am I really enough Sámi or not? Who can tell, and how can we make the definitions? These are very difficult questions, I know, but there are people like me here all over Inari and Utsjoki region. Thank you.
Virvi, did you want to ask your first questions from someone special here?
Well, I tried to look who would be the appropriate person to ask from, but I did not really, I couldn't pick one. I think it's a question that anyone can answer, I mean.
Yes, I think, is there any one of today's speakers? I look for Pia or Matthias. Do you want to say something in this question? Okay, I think we leave it to something we can think more afterwards. Is there any other comments? Now we have a little bit time. No, I don't see. I think we are going to close now this, and we are going to hear two video greetings. Tuomas Blomqvist, who is Minister for Nordic Cooperation and Equality in Finland, and after that Anette Trettebergstuen, who is Minister for Culture and Equality in Norway. And let's see those video greetings now.
Dear Nordic friends, thank you for the invitation to address this conference. I wish I could have been there with all of you in the beautiful Sails in Anar. Finland is currently holding the rotating presidency of the Nordic Council of Ministers. The protection of Nordic indigenous traditional knowledge and intellectual property is a part of our presidency program. I hope this conference and the work done during this past year can be a starting point for future cooperation in this field. The topic of protecting indigenous cultures is very timely. Finland, Sweden and Norway have all started truth and reconciliation processes concerning the Sámi. These processes hopefully teach us valuable lessons about our common history and help us create a better future, whilst motivating us to do better already today. The Sámi have a constitutionally acknowledged position in Finland, Norway and Sweden, and we are committed to protecting the rights of indigenous peoples. The indigenous peoples are a valuable and important part of the Nordic community. Dear friends, the vision for the Nordic cooperation is to become the world's most sustainable and integrated region by 2030. The vision stands on three pillars: to promote a green, a competitive and socially sustainable Nordic region. During our presidency, our motto is the Nordics together. Together is a word with strong connotations to democratic inclusion. Working together is very important when discussing issues that concern indigenous peoples. We need a better and more profound understanding of the broader picture relating to the needs of indigenous peoples, including relating to intellectual property issues. This can only be achieved by lending a listening ear and by asking questions. We could, for instance, start looking at questions like: how can we address specifically the indigenous points of views within the current IP framework? And what are the right levels for this work? It is important to embark on a dialogue together with the indigenous peoples. It is also important to take into account the technological development, which is extremely fast. We need to ensure that indigenous people's point of view is secured also in the digital environment. There is a strong need to have a common understanding across Nordic borders and an understanding of how to address these types of issues. We are well equipped to do so if we are inclusive. The protection of traditional knowledge is also linked to safeguarding biodiversity and the fight against climate change. We should try to align work already being done and find synergies where possible. Dear friends, I hope that the Nordics could embrace the opportunity for this dialogue in the coming years. We could promote the forming of active relationship nationally with respective authorities in IP matters and the Sámi parliaments in Finland, Sweden and Norway. I hope the discussions today have been fruitful and the start of a continuing conversation and for further cooperation. Thank you for having taken part in today's event.
Burrepäivi. Dear Nordic friends, my name is Anette Trettebergstuen and I have now been Minister for Culture and Equality in Norway for about 4 weeks. I would like to thank Finland for organizing this important conference, and I'm sorry that I was not able to join you. However, I'm so happy that we together can continue the good work for a society where the Sámi culture, traditional knowledge and intangible cultural heritage is respected and appreciated. I'm still pretty new in this job, but it's my absolute dream job, and I will focus on Sámi culture, film, music and craft traditions. Respect for intellectual property rights and protection against misappropriation for all indigenous people of the Nordic regions has always been very important to me. Norway, we are committed to promoting the indigenous perspective in all international areas, and we do so. However, the ownership and power of definition of the cultural expressions is, in my opinion, best secured by the Sámi community itself, taking the lead and pursuing a clear role in the work. And the Norwegian government is happy to contribute. Knowledge is an important buffer against misuse. It's therefore vital to spread knowledge about Sámi culture and Sámi traditions and participate in public debate. I'm really happy to see that Sámi artists, cultural workers and institutions take strong and clear ownership of their cultural heritage. I support the Sámi people's role in the constant work of defining and securing their cultural heritage and language. One of my first tasks as a new Minister of Culture has been to prepare the Norwegian chairmanship of the Nordic Council of Ministers of Culture next year. We will continue the good work that has been done in the Nordic Council of Ministers during the Finnish chairmanship. One of the topics we will focus on in the Norwegian chairmanship is to protect and strengthen the Sámi intangible culture heritage. I look forward to a successful cooperation with the Sámi Parliament and the Nordic countries. And I'm convinced that together we can continue to make great things happen. Thank you.
Nanu, temi loapaha ja mun attan tästä manjimus saakavuoru. Suoma saametikki saakatoallai. Tuomis aslaki lääkepuori ja kiihtuu muu asioits. Thank you for me, and you had a long day, but hopefully you got shared a lot of information and it was useful for you, and have a safe trip back home. But now, Tuomis Aslat, lääkepuori.
Olo kiihtuvanne kerstä ja puorit seminaaravassa valtiit. Jyrtsin mun teettekikään vaan englanniskielä täältä karaan tjohkaikeesu tahkaamis tanke tiihtiä tätä päivillä lämmäs on olle massiivalas ja vaarasoihtaa vähän alkipu me tulkaitte. Tää niinku mun inaikku tahka alkis lohpaikeetsu ja onehatsa. Tää oli paha. So thank you for the opportunity. I will use English as I think it's easier to translate the messages that I have taken from the day, and also maybe to be brave enough to vision something for the future. I think we have today heard a lot of really good statements on what kind of role traditional knowledge and cultural heritage has for Samis in our everyday life today. We have heard concrete examples of how intangible cultural heritage should be preserved, secured, and we have also heard in the last part of today's event an important question, how we can make happen more direct engagement of cultural heritage and safeguard it in a way that allows living culture to continue to develop. I think that is important for us, and I think everybody do agree with that Sámi culture is more
over a living culture that is developing. It is not something that we could say as a relic culture. I was really happy to hear the speeches of Silja and Pia. I think that they really concretely allowed us to think about the concrete way to move forward. I myself have been quite active with today's topic as a president and as a member of the Sámi Parliamentary Council to secure that, first of all, the Sámi Parliamentary Council has in its agenda the topic of today. I think that the topic of today has been well carried in the Sámi Parliamentary Council by the Norwegian Sámi Parliament, as they have the main responsibility with this specific topic to work and coordinate our joint efforts. And honestly saying, today, some of the results of what we have been jointly doing was really explained in a good and clarified, with really excellent clarity to what kind of results the project ICAS has had. And then again, really much thank you for Pia and Silja for to my perspective, the one of the most important speeches of today. It's clear that the right to self-determination is something that we have to really carry in our efforts on building practical solutions on safeguarding traditional knowledge and intangible cultural heritage, immaterial rights. It was good to hear Matthias also to a little bit explain the right-based approach for the topic. To me personally, hearing IP rights means, with my experiences in the United Nations, indigenous people's rights. So it is good that in the Sámi context we also take over the IP right in another meaning also and deepen ourselves. We have heard a lot of speeches also about the current opportunities, current possibilities, how to try to safeguard cultural heritage. I myself might not be that convinced that the current systems allows us meaningful safeguarding for our needs. I look more forward for leadership of our people itself to find a solution to how to move forward. I'm really happy that the Ministry of Education and Culture here in Finland has been bold enough to take this topic in the Nordic Ministerial Council. And as a side point, I could say that we, the Sámi parliaments, have been calling for participation for the Nordic Ministerial Council for over 20 years. Now the cooperation brings more meaningfulness for us also, but it also highlights the importance of our participation. I was really encouraged by the words of the Minister from the Norwegian side, visioning that this topic will be continued in the next chairmanship. That allows us to interpret that certain political will and is there for our important topic. In the end, I think that the Sámi parliaments, together with the civil society, have to build a concrete governing system how to function, how to work in this field. The government's role should be in many ways to support it, by resources, by legislations. Of course, we have the Nordic Sami conventions that allows us certain opportunities, but let us remind of all the facts that the Nordic Sami convention is not approved currently. And we are still waiting for the governments to reply for our needs to be fixing the Nordic Sami convention to its form that could be acceptable for the Sámi parliaments. So, and as we heard from the question of Outi Asker today, we do not have time to wait that kind of political will happening in the Nordic countries. So coming up to the critical point, in my view, is that the Sami parliaments have been working, and I would boldly and maybe ambitiously hope that we could, in a fast track, go to concrete work, how we can build, for example, the Sami Parliamentary Council to be the administrative effort or body for this topic. It of course needs full support of all the Sami parliaments, full support from the civil society, but support is also from the governments and the Nordic Ministerial Council. Because as we have greatly heard from Aslak today, it is true that the Sami Parliamentary Council does not have currently resources. It does not have a secretariat. And also examples, and a positive example that was also given by Rune on the Disney cooperation. We have learned that these kind of governing bodies have to be able to function fast. The third sector is not going to wait whether the Sami parliaments will make a decision in half a year or a year. So these are concrete problems what we have to resolve. The political will has to be also measured. I'm just going to be honest and say that in this room currently we have 2 states of the 3 states in Nordic countries. So my hope is that maybe during the or through the Nordic Ministerial Council we could set up or aim or a goal to have a high-level event where the political will of the states to resource and examine their legislations to safeguard our needs would be measured or pronounced. Because if there is a political will, solutions will always be done. I'm most certain that even though the Sami cooperation has some challenges with resources, there is a strong will in the Sami parliaments to make solutions if there is the opportunity is allowed for that. And although saying also that these topics are clearly a question of self-determination, and lead in these issues has to be taken by us, the Sami parliaments and the civil society. So, hopefully the next steps will be happening quite fastly. I'm looking to the Norwegian Sami Parliament, that in the Sami Parliamentary Council Board, we will continue the discussions, hopefully quite fast, and build a specific process where we can, together with the civil society, start to actually write, start to actually build a mechanism where we can move forward. Of course, all the parliaments and their plenaries has to be involved and measured whether, for example, specific mandate could be given to a Sami Parliamentary Council. But it is not unprecedented. We have already stated a big role for the Sami Parliamentary Council to deal with issues and represent the Samis internationally on issues that are dealing us as a people. Thank you for today. Hopefully that everybody has safe travels back home, and hopefully for those calls to make rapid action are satisfied, at least with my personal commitment to this topic, and I'm most certain that some parliaments will together work strongly forward. Thank you for today.